Lord, may I mention this item number 1167 for upgradation matter after filing of the writ petition matter? They have given us a personal hearing notice. That is due on 3rd of February.
Take it 767.
767 matter.
This is challenging what? Adjudication
Well,
order?
this is challenging the show cause notice as without jurisdiction under 74. Our limited ground is that they have invoked 74 without saying what I have suppressed. It is based on total audit, all documents are there, but they have invoked section 74. If my lords converts that into 73, we are happy. We are challenging only to that extent that you cannot invoke 74 just like that by repeating the section and not saying what I have suppressed. And board circular also states that non-payment of tax is not suppression. I have to suppress some material, some information. You have to tell me what I have suppressed. You have taken a view, you have alleged in the show cause notice that I have not paid tax.
Before 3rd, I don't think even on
But
3rd, because there are a lot
I know,
of...
my lord's urgent list is also expanding. What I was requesting, my lord will kindly upgrade the matter. I will write a letter to the officer that my lord has entertained my application to keep it in abeyance till that time. I am grateful, man. So hard pressed, my lord, it's difficult, my lord. I am grateful, man.
Lordship, may we call to mention these two matters, Lordship. One of the matters, Lordship, this is a leave application has been filed for paying for leave before this honorable court for going before the settlement authority. One can application filed. I am only playing with the matter.
To be mentioned,
because it is one more matter is there. This is a ready matter, ready for hearing matter. Lordship, my refund has been withheld since 2007.
Ready for hearing matter will be added in the hearing list. আর ওই একটা ওই ক্যান যেটা আছে
only ওই শালিমারটা only I am playing, Lordship, let the hearing matter be added in the
will be added in the list. না application of to be mentioned দিয়ে দিন না withdraw হয়ে যাবে তো. The writ will be disposed of. To be mentioned দিয়ে দিন.
Yeah, we also kindly to mention on application docket by revenue matter.
Lordship, one indulgence, Lordship. The CAN application, Lordship, will be listed next week, Lordship, because the other side service is still pending, Lordship.
তাহলে application এ দিয়ে দিন. Application এ দিয়ে দিন. Give it under the heading application.
And Lordship, that hearing matter may be added in the list under Lordship hearing.
Application তো একদিন নেব, কবে নিচ্ছি? Application কালকে নিচ্ছি। কালকে দেবেন না? Next week দেবেন।
And Lordship, hearing matter may be added even in the monthly list, Lordship. In monthly.
May your lordship kindly to mention on application, your lordship. The matter was entertained in 2023, your lordship, but the direction was given to give that we will be filing a bank guarantee. Thereafter, the confiscated material will be released, your lordship. We have made that payment. The release was made, your lordship, but now the authority has served a notice upon us. And stating that as there is no specific stay from the High Court, so you unless until you bring a specific order, we will proceed with the execution proceeding, your lordship. There is a heavy fine imposed upon us, your lordship.
Application will appear under application.
There is another hearing matter, your lordship. There is service matter, your lordship. There is clarification hearing.
May I have your lordships kindly, my lord, to mention, my lord, a Jalpaiguri circuit bench matter to file it before, my lord, the principal bench. My lord, the urgency is that, my lord, the GST registration of the my lord petitioner society was, my lord, cancelled without serving any show cause notice and without, my lord, even serving the final order. I'm so
Leave to file.
So
Your lordship, this application was filed for re-export.
Affirmation হয়ে যাওয়ার পরে দেবেন লিফটটা। affirm আছে, affirmed আছে। Yes.
Lordship, this application was made for re-export from this consignment belongs to China, and day by day this charges and other damage charges are added up, and the exporter may have financial hardship to pay off at the end. So my lordship, I'm paying to for the upgradation to the list.
It's there in the list.
My lordship, it's item number 739 and 740.
What is the urgency?
My lord, damage charges and other charges are adding up, and this exporter has made an application.
It will appear in due course. Don't come and mention next day that it is not appearing. I have taken it, it will appear. Please wait for your turn because lot
May I have
urgent matters are there.
May I have my lord's kind leave to mention a group 6 matter, my lord, ready for hearing, my lord, irrespective of classification. My lord, the pensioners of both institutes, my lord, have been suffering, my lord, a policy decision whereby my lord, the 7 CPC has not been implemented in its entire capacity. My lord, 100%, 70% is disbursed. My lord, moreover, in view of a 2005 policy being declared null and void, my lord, which is subject matter of challenge in different writ proceeding, and my lord, the coordinate bench has decided in favor of the writ petitioners, which is under appeal. My lord, I am also facing threat of recovery. But I am pensioners, your lordship.
Yes.
That may just so please accept.
Yes, all good.
Item number 1.
ये भेजे थे। हाँ। This repetition has been yes.
Your Lordship, this matter was mentioned yesterday when Your Lordship sat in the second half. It was appearing under the heading urgent upgraded motions, Your Lordship.
Mr. Roy, your instructions are ready.
Instructions are ready, my lord. My lord keeps it next week. We'll do the matter. My lord, my senior has on lease. My lord.
This matter is appearing under the heading extension of
Jila Parishad matter.
Mr. Sen was there. Mr. Sen has
Yes,
come.
We have concluded on 15th, your lordship. My next
You are in reply. Mr.
Yes.
Tiwari is in reply. Yes.
Now, my lord, Mr. Sen will not firstly argued that so far as section 3 is concerned, that the collector is merely proceeding the matter, will not collector will not pass any appropriate order, will not these are in the
Commissioner. And the appeal will lie before the commissioner.
appeal will lie before the commissioner.
Commissioner.
Now, my lord, so far as that part is concerned, your lordship will not kindly takes my lord once page 37 of the report.
Page 37.
Yes. But lease agreement, my lord, starts at page 36. Now, my lord, if your lordship will not kindly text me at page 37, first paragraph.
Yes.
Whereas the state of West Bengal, represented by the collector of the Murshidabad, granted irrevocable license to the lesser of the land described in Schedule A below and delivered possession the same to the lesser for the purpose of establishing diagnostic cum medical care center under the name and style of Rabindranath Thakur Diagnostic Medical Care Center. So, my lord, collector is the owner of the property in question. Collector is the owner of the property in question, and collector has given collector of Murshidabad granted irrevocable license to the lesser. Lesser is, my lord, Murshidabad Jila Parishad. Now, my lord, kindly takes, my lord, the act, the scheme of the act. Lord, section 2 definition collector means
Collector.
that
Section
is
2.
West Bengal Public Land Eviction of Unauthorized Occupant Act.
Section 2.
Section 2.
Section 2.
2(1).
1.
2(1).
Yes.
Collector means in Calcutta, land acquisition collector, Calcutta, I am not coming under that. Next, B, 2(1)B. Elsewhere, the chief officer in charge of the revenue administration of the district. The chief officer in charge of the revenue administration of the district, that is the Milord district magistrate or collector. Now, Milord, and includes an additional district magistrate, subdivisional magistrate, and any executive magistrate specially appointed by the state government to perform all or any other functions of a collector under this act. Now, my lord, if your lordship will not kindly see, my lord, 4. 2(4). Owner. Owner means in relation to any land belonging to or taken on lease by or requisitioned by or on behalf of the state government, that government, that is the state government. If the state government is the owner, the state government, if the land belongs to the state government is the owner. Next, in relation to any land belonging to or taken on lease by a local authority, company, corporation, and such local authority, company, corporation, as the case may be. So, Milord, in view of Milord section 2, subsection 4(b), Milord, Jila Parishad cannot be the owner. And again, I may read it. In relation to any land belonging to or taken on lease by a local authority, company, corporation, such local authority, company, corporation, as the case may be. Now,
But
Milord, if
Zilla
you
Parishad is a local authority.
no, now Milord, kindly have a look, Milord, page 37 once of the writ petition.
Is 37.
Jila Parishad is a local authority. There is no doubt.
Yes.
Whether the local authority is the owner of the property in question or the local authority has taken the land on lease or not.
No, but for the purpose of this act,
Huh.
even if the person has taken lease, that local authority being a lessee will be treated as the
No,
owner.
but
That
Jila
is
Parishad had not taken the land on lease. That's why I am referring to the page 37.
very well.
Page 37, kindly have a look, page 37 once.
Yes.
Whereas the state of West Bengal, represented by collector of Murshidabad, granted irrevocable license. This is not a lease. Have you also got it, Miller? Page 37 of the writ petition.
Yes.
First paragraph. Page 37.
Page 37.
First paragraph. Whereas the
Irrevocable
state,
license.
whereas the state of West Bengal, represented by the collector of the Murshidabad, granted irrevocable license to the lesser.
Yes, sir.
To the lesser, license to the lesser.
So you want to say that he is not a lessee, he is a licensee.
Yes, he is a licensee. So, Milord, Jila Parishad is not the owner of the property in question in view of Milord section 224(b). Now, Milord, kindly take Milord Act itself, section 3. The collector is the owner. I am not disputing that. DM is the owner of the property in question.
Just. No, owner will be state then. If
State represented by DM.
Yes.
Owner, it says Milord that
by the
owner
collector.
first definition, section 2, subsection 4(a). It says in relation to any land belonging to or taken on lease by or requisition by on behalf of the state government, the government. That means the state government is the owner. And
But
collector.
what will be the effect of an irrevocable license, Mr. Tiwari? If the license is
But a
usually
license is always license.
no, but it is only then a case of nomenclature.
Is
You will,
not
you,
so.
we will have to see the
No,
object also.
no, no,
If-
no, no.
although the document may be captioned as a license,
Even if
but
like
if it is irrevocable in nature, it is no longer a license.
the blood so far as irrevocable
License is always revocable.
license is irrevocable
It should
and
be a permission.
irrevocable,
Otherwise,
irrevocable license is also Milord in my responsible submission Milord is a meaningless term. Irrevocable license.
no, but if they have used it, does it not in a sense
But whether Milord
connote lease?
whether it can be considered as lesser. Milord, otherwise Milord it could have been used with a lesser. Well, a license is license, lease is lease.
No, but
There is
there is a line of decisions in this
yes,
context
Milord, there
also
is a
that
line of
it-
this now Milord, your lordship
that
knows
merely
Milord.
because you have called it a license, it may not be a license unless
That is a way of interpretation and all these things will come. Whether will a tenancy is a lease or not, whether lease is a
because
tenancy or
since
not.
this point is
No.
being raised now that it is irrevocable license.
Irrevocable
because
license.
it
Well,
says irrevocable license.
I am going
I
at the
cannot
statute.
read the word license divorced from the preceding expression irrevocable.
Absolutely,
Now,
Milord.
if the license is irrevocable, what will be the effect?
Irrevocable license, Milord, it includes the term of license. Even if it is irrevocable, it cannot be termed as Milord lesser. Well, in terms of Milord, then in that case, Milord, the owner definition would have been changed. It could have been said, Milord, irrevocable license also included. The Milord, definition of owner is clearly says that in relation to any land belonging to or taken on lease by a local authority, company, corporation, such local authority, company, corporation as the case may be. So, Milord, my first point is this, that so far as the Jila Parishad is concerned, Jila Parishad Milord cannot be termed as lesser or Jila Parishad cannot be the owner of the property in question. The property owner is the state and state is being represented by the collector. That means Milord DM, District Magistrate.
Yes.
Now, my lord, if you lordship, Milord, can you take Milord page 45 of the
45.
45 of the repetition?
Yes.
Now, you lordship find Milord the schedule of the property. It is Milord under Khotiam number 1. Your lordship knows Milord Khotiam number 1
No,
the
state.
state is the owner. The Milord plot number is Milord 960. Can you have a
Yes.
note? Plot number is 960. Now, Milord, can you take Milord section 3 of that?
Section 3 of
Section
that.
3.
Yes.
Section 3 says, Milord, issue of notice to show cause against the order for eviction of unauthorized occupant from public land. It says, if in respect of any public land, the collector is of opinion, upon application made by an officer of the owner of the public land authorized in this behalf by such owner, or upon information received otherwise. So, Milord, the owner may apply to the collector, or the owner may authorize anybody to apply before the collector, or upon information received otherwise. It can be, Milord, from third party also. Upon information received from otherwise, that the public land is in unauthorized occupations of any person or persons, the collector shall issue a notice in such form and containing such particulars as may be prescribed, calling upon all concerned persons to show cause before such date, not being less than 15 days from the date of the notice, as may be specified in the notice, why an order of order under subsection 1 of section 4 should not be made, and shall cause it to be served in the manner referred to in subsection 2. Intimation of the date so specified shall be given to the owner of the public land or to his authorized officer under this subsection. Well, why I am reading that? But it says not if in respect of any public land, collector is of the opinion. The collector, who is the collector? it has been argued the collector is the SDM. So, my lord, collector is receiving information from the owner of the land or any information from anybody. It says, my lord, upon information received from received otherwise. Now, my lord, kindly see section 3. Now, my lord, section 3 will not follow section 4. My lord, section 4 says what? It says, my lord, if after considering the cause, if any shown
But
by
in reply, new case.
No, new.
I thought we were
no new section 3 has been referred, but Mr. Sen did not refer section 4. Section 4 my lord, gives the power to evict me, the same officer. Section 4 my lord, says section 4 gives the power to evict me. It is not my lord, the section 3 is just SDM is not considering the cause and SDM will stop there. No. SDM is considering the cause and thereafter SDM will pass consequential order for eviction. That's section 4. So it is not a case, even if the suit is pending and interim order is there, the SDM will proceed the matter and thereby stop there. No. SDM will pass order of eviction. So, my lord, section 3 follows section 4. Now, my lord, my case is this, why I am saying so. My lord, in the show cause notice, my lord, kindly text my lord show cause notice once. Page 100.
Page 100.
Yes.
Yes.
Page 100, my lord says that the additional executive officer, Murshidabad Jila Parishad, has informed the district magistrate Murshidabad, via memo number dated such and such, that besides NSBC deputy Bahrampur Murshidabad, situated on plot of land 960 part 915 part, but it is not tallying with the lease deed also. Such and such district Murshidabad had been leased out by the Murshidabad Jila Parishad in favor of Asia Healthcare Development Private Limited, Chatterjee International. Address is here with a direction to give vacant peaceful possession of the nursing home within a period of 15 days from the date of issue of such letter. The additional executive magistrate Murshidabad Jila Parishad has placed the proposal before the district magistrate to take necessary action for eviction of the unauthorized documents. The Messrs. Asia Healthcare Development Private Limited from the premises of Rabindranath Tagore Diagnostic Medical Care Center by invoking the relevant section of the West Bengal Public Land in the Eviction of Unauthorized Occupant Act 1962. The matter is duly forwarded by the district magistrate Murshidabad to me for drawing necessary proceedings. Hence, in my considered opinion, the illegal encroachment are required to be removed and evicted from the public land for restoration of the lawful possession of the plot number such and such by the immediate owner, the Murshidabad Jila Parishad. Being satisfied to that effect, I, Subdivisional Magistrate, Bahrampur, Sador, Murshidabad, being the collector as per provisions of section 21B of the West Bengal Public Land Eviction of Unauthorized Occupant Act 1962, as amended from time to time, in exercise of my power vested in section subsection 311, do hereby such and such. Now, my case is this. Here, Chief Executive Officer, Additional Executive Officer Murshidabad writes a letter to the DM. Now, DM is not, in this case, DM is not acting as collector. Suppose, my lord, information received from anybody by the collector, then DM could have proceeded with the matter. But here, what is the case? Case is not information received by the DM from the Chief Executive Officer of the Murshidabad Jila Parishad. Chief Executive Officer of the Murshidabad Jila Parishad is not the owner, is not the representative of the owner, is a third party. Third party giving information to the DM. Now, who is the DM? I am asking the question to myself. DM is the owner of the property in question. Now, can you see? Third party giving information to the DM. DM is directing the SDM, a quasi-judicial authority, to proceed. And the SDM is proceeding on dictation of DM. So, the owner is giving direction to the authority, a forum, to proceed against the tenant. So, this is absolutely violation of principle of natural justice. And DM is not acting as dual capacity. Here, DM role of the DM is, in my responsible submission, is nowhere. As per the scheme of the act, or if the property, Khotian one property, the DM is the owner of the property in question, being the head of the revenue of the district.
But you cannot equate the state with the DM. DM
No,
will
no,
not.
in district, we will not kindly consider.
Owner
DM
is
will,
the state. State will have to be represented by the governor, not the DM.
so far as state is concerned, we will not kindly see, we will not.
Say state.
Yes. Now, so far as we will not lease deed is
So
concerned, we will
it cannot be taken to be the owner's
not.
dictation.
Yes, lease deed will not says will not collector. Represented by state of West Bengal, represented by collector. Page 37. It is not represented by the governor. Now, my lord, what he has done, my lord, DM, my lord, could have acted, my lord, as collector in this case, but DM did not do so, as because DM knows the DM, my lord, is represented the state of West Bengal. So, my lord, DM is the, my lord, representing the owner. If the DM is representing the owner, my lord, the DM cannot act as a collector. So, my lord, in this case, my lord, what happened, my lord, the information given by third party to the owner is directing the quasi-judicial authority, and the quasi-judicial authority is acting on dictation, my lord, to proceed against me. And in one proceeding, my lord, there cannot be two collectors. My lord, DM, again I am repeating, my lord, DM could have acted as collector, but DM did not do so. The collector here is, my lord, the SDM. Now, my lord, next argument, my lord, advanced by Mr. Sen, that SDM is the collector, appeal lies to the commissioner of the division. Yes, my lord, he is correct. I am not. I am joining the issue, my lord. That was my misinterpretation. He is correct. Now, my lord, so far as DM is acting in dual capacity, my lord, I have said, my lord, DM is not acting in dual capacity. DM has no role in the scheme of the act itself. In the scheme of the act, does not render any power to the DM to act. And the moment he is, my lord, on the if the information given by the owner to the SDM, so well, DM seizes his power. Now, my lord, so far as, my lord, this special, so far as, my lord, the show cause, that it has been argued whether there is a mere show cause, nothing has been decided, so, my lord, read does not lie. So far as this part is concerned, my lord, I guess Mr. Sen has referred, my lord, one judgment, that is, my lord, 2006 12 SSC page 28.
Yes.
2006 12 SSC page 28, well, there's a Union of India versus Kunisetti Satyanarayana. Now, my lord, in that judgment, my lord, Mr. Sen has referred, my lord, I'll be just referring, my lord, two paragraphs, that is paragraph 15 and 16.
Yes.
Paragraph 15, my lord, this is in respect of a service matter, my lord, where the charge sheet has been challenged, my lord, by way of filing the petition. It says, my lord, paragraph 15, the writ jurisdiction is a discretionary jurisdiction, hence such discretion under Article 226 should not ordinarily be exercised by quashing the so-called notice or charge sheet. No doubt, in some rare or exceptional cases, High Court can quash the charge sheet or so-called notice if it is found to be wholly without jurisdiction or for some other reasons it is wholly illegal. However, the ordinarily High Court should not interfere in such a matter. So, my lord, it is absolutely, my lord, it is up to your lordship, my lord, whether the discretionary power has to be exercised by your lordship or not, considering the facts and circumstances of the case. Now, my lord, I just referred, my lord, two judgments, my lord. That is, 2016, my lord, 12 SCC page 33. This is 2016 12 SCC page 33.
2006 12 SCC.
Sorry, 2006 12 SCC page 33. Now, my lord, I just refer two paragraphs, paragraph 9 and 10.
Yes.
Paragraph 9 says, well, although ordinarily a writ court may not exercise its discretionary jurisdiction in entertaining a petition, questioning a notice to so cause unless the same interiorly appears to have been without jurisdiction as has been held in the case of such and such and such. But the question herein herein has to be considered from the different angle. When a notice is issued with a premeditation, a writ petition would be maintainable. In such an event, even the court directs the statutory authority to hear the matter afresh. Ordinarily, upon such hearing, would not yield any fruitful purpose. It is evident that in the intense case, the respondent has clearly made up his mind, and it explicitly said so, both in the counter affidavit as well as in the purported so cause notice. The said principle has been followed in the case of such and such and such. So, my lord, here you also would find, my lord, in the subsequent orders passed by the SDM, SDM is determined to, my lord, pass an order of eviction. So, my lord, the formal, it will be absolutely an empty formality to ask the SDM to proceed with the matter. 2006, 12 SCC, page 6, 12 SCC, page 33. Page 33. Now, my lord, another judgment to that effect, my lord, your lordship, my lord, can you see, my lord, in the compilation I have given 2010 13 SCC 427. 427. Here also the same thing. Here, my lord, I just referred, my lord. Kindly have a look, my lord, paragraph 27.
Paragraph
Paragraph
27.
27. Citation, please. 2010 13 SCC 427.
Yes.
Paragraph 27 says, my lord, it is no doubt true that at the stage of so cause, the person proceeded against must be told the charges against him, so that he cannot take his defense and prove his innocence. It is obvious that at the stage of that authority issuing the charges cannot, instead of telling him the charges, confront him with the definite conclusions of the alleged guilt. If that is done, as has been done in the instant case, the entire proceeding initiated by the so-called notice gets vitiated by unfairness, bias, and subsequent proceedings become an idle ceremony. Justice is rooted in paragraph 28. Justice is rooted in the confidence, and justice is the goal of the quasi-judicial proceedings also. If the functioning of the quasi-judicial authority has to inspire the confidence in the minds of those subjected to its jurisdiction, such authority must act with utmost fairness. In fairness is obvious to be manifested by the language by which the charges are couched and conveyed to such persons proceeded against. Now, my lord, kindly take, my lord, paragraph 32 and 33. Paragraph 32 says, my lord, therefore, while issuing the show cause notice, the authorities must take care to manifestly keep an open mind, as they are to act fairly in adjuring the guilt or otherwise of the persons proceeded against, and especially when he has the power to take punitive steps against the person after giving him a so cause notice. The principle of justice must not be done, but it must eminently appears to be done, as is well equally applicable to the quasi-judicial proceedings, if such proceedings has to inspire the confidence in the mind of those who are subject to it. So, my lord, my case is this, my lord, that here in the case, my lord, you also would find the way he is proceeding, my lord, I know the result of this case. Now, my lord, I'll just cite, my lord, Vidya Dhulia once again. Now, my lord, in Vidya Dhulia, you'll also find this one paragraph that it has been submitted by Mr. Sen that so far as special statute is concerned, my lord, that is outside the scope of arbitrability. The Lord, straightway comes to paragraph 53 of Vidya Dhulia.
Paragraph?
Paragraph 53.
Yes.
Paragraph 53, my lord, kindly read, my lord, last 4 lines. It starts from therefore. Therefore, has you also got it? Therefore, mere creation of a specific forum as a substitute for civil court or specifying the civil court may not be enough to accept the inference of implicit non-arbitrarity. The conferment of the jurisdiction on a specific court or creation of a public forum, though eminently significant, may not be the decisive test to answer and decide whether arbitrability is impliedly barred. Now, following this paragraph, there is a recent judgment of the Honorable Supreme Court, my lord. I have also, in my compilation, my lord, you will also find there is Motilal Oswal Services, Financial Services.
Yes.
Now, in this judgment, my lord, your lordship, my lord, can I transfer, my lord, paragraph page 21 first. In the bottom, my lord, your lordship would get page 21. Page 21, my lord, B. Vidya 2 actually occasioned due to the another judgment of this Honorable Court in Himangni Enterprises versus such and such, which has treated the cases of ejectment under the Transfer of Property Act similar to the cases of eviction under the Rent Control Act of the state. The bench in Vidya 1 doubted the said judgment and in detail referral, the order distinguished the applicability of the prior judgment of this court in the case of such and such and such. Now, my lord, next page. C. While deciding with this with the aspect of implied bars on arbitrability, Vidya made the following pertinent observations. Now, paragraph 53 has been quoted. I am not saying. Now, paragraph 53 quoted. Bold portion you will also find, which I have read to your lordship, lord. Page 22, paragraph 53 quoted, and emphasis supplied, lord, so far as this bold portion. Therefore, has you also got it?
Yes. Yes.
Now, page 22 of this judgment.
Yes.
Now,
The same thing has been emphasized.
Yes, emphasize. Now, my lord, next, my lord, if, next page, my lord, if lordship, my lord, can you turn? Page 23.
Yes.
There is D.
Yes.
It further, for completion of the records, it is also mentioned herein that Vidya 2 expressly overruled Himangni and held as under. Now, my lord, paragraph 79 of Vidya quoted by the Supreme Court. Thereafter, paragraph 80 was quoted. Now, my lord, kindly turn, my lord, next page 25.
Yes.
Page 25, 4.
Yes.
Fourthly, the arbitration clauses have their roots in section 28 of the Contract Act 1872. The provision completely missed in central, whereas in supra, the section 28, which speaks of the agreement in restraint of the legal proceedings being void, has two important exceptions. The relevant part of section 22 and exceptions are extracted herein below. Section 22 an exception was extracted. Now, my lord, it says thereafter, it will be clear that when two or more persons agree to refer the matter to arbitration, section 28 will not render that agreement invalid. Now, my lord, next, considerable argument were advanced both in the oral submissions as well as written notes about whether the nature of the claim is in the form of the debt or whether it pertains to a matter covered by the ambit of section 41(1). The arguments are also advanced to the issue as to how dispute between the parties in a dispute in personam as contained by the respondent pertaining to only to recovery of the debt and opposed to the appellants contending that the dispute relating to the recovery of the license fee or the charges of rent are covered under section 41A of the 8082. Reliance was placed such and such and such. Now, paragraph 23. In exercise of our jurisdiction under section 11, we are not concerned with the said dispute. that will be for the arbitrator to decide. We have to hold that the arbitrator has taken a decision on section 16 applications. If that is so, the parties have to work out of their remedies in accordance with the law. As and when the remedies are resorted, and they will be decided influenced by the observations made herein. All questions between the parties are left open and all these things. Now, my lord, 16 was quoted, and thereafter, ultimately, my lord, the matter was referred to the arbitrator. So, my lord, here also, my lord, the special statute, general statute had came into consideration by the Supreme Court. Now, my lord, kindly consider one thing. Now, my lord, so far as my lord, special statute is concerned, my lord, your lordship, my lord, knows, my lord, the landlord-tenant relationship, my lord, is basically, these are all beneficial legislations for the, my lord, particularly for the purpose of, my lord, protecting the tenant. These, my lord, special statutes, my lord, are created, my lord, giving some privilege to the tenants. Now, my lord, these rent control legislations, my lord, this,
But I can take your lordship.
Yes, yes.
these rent control legislations, my lord, is for the purpose of.
I have 5 minutes on the next Thursday
Yes,
just
of
to
course.
reply?
Why not? Next Thursday, I think I have another matter and we have it on next to next.
I will take only 5 minutes, sir. Because I will not go into the facts, just these 2 or 3 judgments which my learned friend had said, that only I will deal with that, nothing else. দেখি যদি হয়ে যায় চলে যাচ্ছে।
Yes.
Now, my lord, these statutes, my lord, your lordship knows, my lord, these special statutes have been created, my lord, for the purpose of, my lord, particularly for the purpose of protecting, my lord, weaker section of the society. Now, my lord, here the case is just opposite. Now, my lord, kindly consider one thing. When we enter into an agreement, my lord, Jila Parishad is normally should be treated as an individual. I enter into a commercial agreement with the Jila Parishad. Now, my lord, agreement goes on. Subsequently, my lord, Jila Parishad, my lord, trying to resort these provisions of this act. Now, my lord, here the landlord is taking benefit, depriving the statutory rights of the tenants. Just opposite, my lord, to what, my lord, to the scheme of the act itself. The scheme of the Rent Control Act, my lord, it says for the purpose of, basically for the purpose of protecting the weaker section of the society. Now, my lord, in this background, my lord, now, my lord, if your lordship, my lord, kindly takes the order passed by Section 11 Court. Well, it is 9th December 2025.
Yes.
May I just read out paragraph 3. Dispute cropped up between the parties with regard to an alleged termination of the tenancy or lease when the respondent issued a letter dated January 11, 2022 on various allegations of neglect and failure to pay the rental agreement. The suspicions was also raised with regard to the actual amount collected by the petitioner to run the hospital and the purported figures which were disclosed to the respondent. Challenging such termination notice, a suit was filed with the civil judge, Senior Division, First Court, Murshidabad at Boram. In the said suit, the respondent filed an application under Section 8 of the Arbitration and Conciliation Act. Referring to Clause 28 of the said agreement, the respondent contended that the dispute between the parties which arose out of the terminations letter should be decided in arbitrations. The learned trial court rejected the applications and granted an injunction till the disposal of the suit. Both these orders were challenged. An appeal was prepared by the respondent before the Honorable High Court, before the Honorable Court filed FMA number such and such. In the said appeal was allowed by the judgment dated July 15, 2025. The division bench was of the view that dispute between the parties ought to have been referred to the arbitrations by allowing the applications under Section 8 of the said Act. The part of the said impugn order by which the injunction was granted in favor of the petitioner was held to be without jurisdiction, as the bench was of the view the trial court was duty bound to refer the entire dispute to the arbitration instead of entertaining the suit and deciding the prayer for injunction. Mr. Sajan, appearing for the petitioner, submits the specific observations of the division bench was that the dispute between the parties were raised in the suit were governed by the arbitration clause. The dispute was thus referred to the arbitration. Reliance has been placed to the reasons supplied by the bench in support of such contention. It is submitted the petitioners would be non-suited if the objection. Yes. Now, will kindly one paragraph 7. Once I just paragraph 7. Under such circumstances, I do not find any impediment in referring the dispute to arbitrations, irrespective of the fact that an eviction proceeding is pending before another forum. The continuation or validity of such proceedings is not to be gone into by the referral court. Next, the learned arbitrator will adjudicate the dispute in accordance with law. and the respondents will be at liberty to raise the issue of non-arbitrability of any of the claims of the petitioner in the event such claim overlaps the jurisdiction of the authority under 1962 Act. So, my lord, my simple reading of these two lines means, my lord, the respondent has to raise an objection before the learned arbitrator under section 16 of the Arbitration and Conciliation Act, and the learned arbitrator was given the jurisdiction to decide this. Otherwise, my lord, you lord, and my lord, there are two judgments on this issue. First is, my lord, division bench referred the matter to the arbitration. That is on 15/7/2025. Thereafter, my lord, entire dispute was referred to the learned single judge of this Honorable Court on 9/12/2025. Both these orders, my lord, they have not challenged it. They have accepted this order. And my lord, 15/7/2025 order, my lord, is on their appeal. Now, my lord, kindly consider one thing: the division bench, single bench. Both these orders will be nullified by quasi-judicial authority. When, my lord, when the quasi-judicial authority, the jurisdiction to decide the dispute has been referred to the arbitrator, and the Jila Parishad has been given a liberty to raise the issue before the arbitrator, and the single bench, division bench order would be nullified by the quasi-judicial authority.
Yes.
And, my lord, another point has been raised by Mr. Sen, that by referring, my lord, this section 8A of the Act,
Civil courts jurisdiction.
My lord, it says, my lord, barred, civil court jurisdiction is barred. The bar to jurisdiction of civil courts. No civil court shall have jurisdiction to decide such and such. Now, my lord, kindly consider one thing: the 1996 Act and, my lord, 1962 Act. Now, my lord, both the acts, my lord, both the acts should be read, my lord, harmoniously. Otherwise, my lord, the entire scheme of 1996 Act would be given, my lord, absolutely go by. My lord, what the submission was made, my lord, even if the award is passed by the learned arbitrator while exercising power under 1996 Act, that award cannot be executable or cannot be executed before the my lord civil. This is, my lord, with deepest of respect, my lord, this is, my lord, people's style argument. My lord, the 96 Act has a scheme, 1962 Act has another scheme. My lord, even if both the acts, my lord, overlaps, it has to be, my lord, constituted, my lord, harmoniously. Otherwise, my lord, the entire scheme of 96 Act will go. And, my lord, in that case, my lord, your lordship, my lord, can you remember the central warehousing case? The Supreme Court allowed both the proceedings to be continued. And, my lord, in this case, my lord, what happened? In this case, the issue is, my lord, referred to the arbitrator. And that's why, my lord, liberty was given to the Jila Parishad to raise the issue under section 16 before the arbitrator. If the arbitrator decides against me, I will go there. These are my submissions, my lord. I have also submitted my written notes of argument. And the judgment, my lord, which I have already handed over to you, that was not annexed.
Not required. Mr. Tiwari, learned senior.
Good.
Nothing.
Okay, what I was trying to impress upon, madam, and I will only stick to that.
Mr. Rai, biggest problem is delay.
My, I
There is
understand.
no explanation. See,
I-
a writ court is also a court of equity. I am bypassing or allowing you to bypass the statutory remedy only because you have shown expedition in approaching the writ court. If your approach to the writ court is tainted with delay and that delay is not explained, no doubt, yes, even if it is delayed, there is an explanation. I can definitely exercise discretion and entertain the writ petition despite delay. But if even a small delay is there and that has not been explained, becomes difficult for me to cross the threshold.
My lord, may I answer to that? My lord, there is, if I can state it in terms of time, lordship, a clear delay of 3 months is there.
Not 3 months. Not 3 months.
Lordship,
Your knowledge at least can be attributed to you from the date of your alleged eviction. That is in August.
August
Your
28th,
writ petition is in December. It's not 3 months.
lordship, September, October, November, 3 months. Lordship.
December. December also.
My first application, lordship, my representation is in November 11th.
Representation. That again cuts a sorry figure. A person who is dispossessed, is that due dispatch? A person who is dispossessed makes the first representation after 3 months. How do I? There is scanty material on record even to evince that you have continued in possession even after that 2011, because he is disputing that. How will the writ court decide all this?
My lord,
How will the writ court decide all this?
I bow down.
I cannot decide because these are all to assume that no notice has been given to you. I will have to first assume that you have continued in possession.
That is,
Apart from your averment in the writ petition and the 2011 document, because yesterday his submission was that after 2011 you may not have been in possession, and he is right in submitting so. Where is the document? Where is anything on record except a bald averment that you were dispossessed in August 2025?
lordship, to that extent,
There is nothing. August 2025, there is no contemporaneous objection on your part saying that I have been dispossessed. Kindly restore possession to me. How do you suddenly expect the writ court to do? Now the certified copies that you have annexed, they belie your
no,
assertion
these are
that you
not
did
the
not.
certified copies,
They
lordship.
are.
This
They
I have
say
got subsequently.
they say certified copy. They are. It's printed over there. The stamp says certified copy. Please see page 36.
Yes.
Yesterday I saw that. I have
Yes,
marked it.
Yes.
Says certified copy. You
Lordship,
have applied.
lordship,
You have annexed it to your writ petition. There is no explanation what the name that these certified copies were obtained by you later on, or whatever it is. Whatever is coming to me is coming from the bar. I cannot take cognizance of that.
No.
Being a writ court.
No.
So there is no handle for me to proceed further.
Well, this proceedings has been
Mr.
initiated.
Nag, when, how was he dispossessed? When was he dispossessed? What is this?
Whether he was dispossessed, I don't know. According to his position, position was according to his averment. Position was taken in the August 2025.
And according to you, when was possession taken?
Position August 2020. But
From
whether
whom?
he was in position or not, I don't know. Padlock was put on the premises. And in respect of the goods lying here, we have already initiated proceeding under section 6 as well as mandated. Now, what has fallen from your lordship on last occasion, I just want to say, not only delay, the certified copies of 10th April 2025. Now, if a person has lost his right to appeal, whether he has any right whatsoever to seek minor extraordinary rate.
That was the point I was putting to him also. Mr. Rai, why don't you prefer appeal? I'll grant you liberty, prefer appeal, because this writ court, I am loath to interfere with this because the facts are gory. It's not a very happy
May I
position.
make one humble attempt,
Yes.
and this is my last attempt. My lord, it is an admitted position that they have taken steps under a particular statute.
Yes.
The statute talks about the plain reading of the statute, lordship. It talks about the public premises eviction of unauthorized occupants.
Now, my lord, under section 4 and lordship,
He
why-
is disputing your occupation also,
my
Mr.
lord,
Raj.
that is not an affidavit. That is again from the
I
bar
can
because
invite affidavits, it
Yes,
won't serve any purpose.
lordship,
There'll
lordship
be
may
no
kindly
stay,
invite
nothing.
that. Lordship may
Because-
kindly invite that
What
because
is the use? First, you cross the threshold of your writ petition being maintainable. You cross the threshold of delay.
lordship, the question
Because
of lordship.
If I would have invited affidavits on the first day itself, that would have been the end of the matter. But today, when we have entered this much and there is nothing on record to show that why you were silent for all these days, nothing, not a single line. This is not how I can entertain a writ petition. Then there is no use.
May I kindly, lordship, just for my satisfaction, lordship. Lordship, I will keep citing one judgment. Only one. And this, lordship, this is what I could find yesterday night, and I think it would be of some relevance. Lordship may dismiss my writ petition. I cannot stand it. Lordship, this is 1984 SCC, sorry. 1984 SCC 435. My lord, I will only be. May I kindly give what the facts are, man? Lordship, the facts would appear from paragraph number 2. The facts, what had happened here, that a person was inducted under the erstwhile landlord. That landlord thereafter sold the property to LIC. The tenant remained. LIC, what they did, they issued a notice under 106 and thereafter a proceedings under the eviction of unauthorized occupants. Now a defense was taken that initially I had a lease in my favor and hence I cannot be called an unauthorized occupant. That the Supreme Court clarified, and which the section also clarifies, that if a person for the initial period was in a legal occupancy and subsequently due to termination or determination of the lease period, if it has come to an end, then he would be termed as an unoccupied occupant. Lordship, this entire act, and Lordship, I say with some responsibility, I'd be happy if I'm being corrected. This entire act does not talk about possession. It talk about occupation. Now, Lordship, may kindly, in light of such discussion, Lordship, may kindly take up the judgment which I have handed over. Lordship, may kindly turn over 2 pages and come to paragraph number 5. This is at page 439. I am reading the last paragraph to begin with.
Yes.
To begin with, it is manifest that section 2G does not use the word possession or the word entry into possession. So they say that they have entered into it. At any point of time at all, the section merely requires occupation of any public premises. Entry into possession connotes one single terminus. The point of time, I'm sorry, I have handed over. The point of time when a person enters into possession or occupies the property, whereas occupation is a continuous process. I am in a continuous possession.
That is your assertion, sir. That is your assertion. How, as a writ court, will I immediately believe that your occupation was seized in August 2025? There is no representation or objection
I have
to
been
such.
carrying on business from the safe premises. That is my averment.
All on averment, sir.
Yes.
There is no document.
That is on oath.
There is no, maybe on oath.
And
The other line should also have been on oath as to why you have not approached court or why have you not approached these authority itself, where you have been continuing with business for 30 odd years.
Not put on notice, Lordship. The humble.
Not put on notice. Your dispossession was to your notice. You were dispossessed.
Yes. Yes, that is why I
The
was.
first representation after your disposition in August 2025 comes in November 2025. What is your explanation to
My-
that? There is nothing. There is nothing. How will a person of normal prudence believe that a person who has been in occupation for 30 years is one fine morning dispossessed, but he does not object to it to it for at least 3 months thereafter? How is this possible? How is this believable? How will the writ court believe this? What document have you brought before the writ court to believe this? You are putting your case high. I can understand that. That you are entitled to. But for me to be entitled to be passing an order in your favor, I will also have to have some document, some basis. On what basis will I pass this order? How will I entertain this?
I follow, my lord. My lord, to that extent, Lordship, I would again fall back to the document which I had earlier shown. My lord,
That was of 2011.
My lord,
From
nothing has
2011
changed after that. My
that
lord,
is again your averment. Where is anything to show on record
Lordship,
that you have been in possession? Nothing. Your own
Lordship, may I-
representation is 3 months after your disposition. This
Lord-
is something which highly goes against you.
Lordship, they must have been using electricity. May I produce the electricity bills?
It should
my
have
lord?
been here now, sir. It should
May-
have been here
by-
now.
by
I
tomorrow-
will not enlarge the scope of the
No, no,
discussion
no,
by
not
giving
at
you chances to produce file supplementary electricity. That should have been the case. It's not there. It's not there.
Lordship,
You go before the appellate
it-
authority. No, sir.
Lordship, may I
Yes,
finally,
place your
finally
judgment.
place
Please.
the point of time when a person, I'm reading from the first line, my lord. The point of time, this is page 440. The
Yes.
point of time when a person enters into possession or occupies the property, whereas occupation is a continuous process which starts right from the time when he enters possession or occupies the premises and continues until he leaves the premises.
Correct.
So
No,
until I have left the premises, and if they say that they have recovered possession from me,
They don't
shows-
say that.
Yes, my lord.
They don't say they have recovered from you.
They have.
They don't say that. Just few minutes back, Mr. Nath
Lordship,
stood up and
they-
said
I'm-
that
I'm-
I have not recovered it from you. We have just put a padlock. Whosoever might have been in
Lordship,
possession.
my
You may be representing somebody else may be representing somebody else.
Lordship,
That is not how
the
that is all the more reason for writ court not to enter into this arena. It should be fought out before an authority who is entitled to take evidence, not the writ court. In summary proceedings, how will I do? He will file an affidavit saying no. You will file an affidavit saying yes. Oath versus oath. How will the writ court decide? Yes, Mr. Nath.
Well, just only one line. This judgment, the ratio decided in this judgment. Even if somebody came into possession or occupation of the premises, but after Premises Act came into effect, it will be governed by that. That is the ratio of
No. The ratio of this twofold. Let me
8
clarify.
and 9. That's it.
Let me
I have
clarify. Sir, you may please go through the judgment at your leisure. There are 2 points, in this judgment which I should. As I was indicating, the facts were they took a defense that you cannot call me an unauthorized occupant. I am governed by a separate statute. To which the court said, no. The moment you are continuing in an occupation and you have suffered a notice under 106, no matter even the period before that was a permitted period, but post the determination of the lease, you become an unauthorized occupant, which the section absolutely takes care of, which I had placed on the last occasion. Section 4 is very clear. There are 2 categories of people. One, from day one, you are a trespasser, you are occupying the public premises. Second is you were given permission, but today, for default or whatever reason, upon termination, you are no longer legally occupied. So you at best can be held as an unoccupied, unauthorized occupant. That was the distinction, my lord. I cannot. I should have read the entire judgment and place it. I will never place something which.
No, not with that.
That is my duty.
well, it will take nice. You can see number only one thing. Well, here he has already lost his pass to fight that. Well, don't give him any liberty. If it is allowed in law, it will. Or well, on the
My lord,
basis
that
of-
is exactly where I am, because the appeal, my lord, if the notice is not served upon me, I am not made a party. I am in occupation of the land.
that the
This
appellate court will
this
see.
perhaps lordship would be would be proof enough that what are their actual intentions. They want to secure
I
a
don't
degree.
have any intention.
They want to secure. Lordship,
Plan to stop. You are not stopping. You are not allowing me to say, I don't know. You should stop when you are arguing the matter at some point of time. Now, my lord, here my submission is, my lord, under section 9, there is, my lord, the forum, he will decide whether he is at all entitled to, whether lordship does not have to give any leave. If he is entitled, he can obviously approve. Or, my lord, on the basis, what happens on the basis of that, my lord, there the provision of limitation is very rigorous in section 9. So, my lord, that gets condoned, my lord, automatically. That's what, my lord, my intention for your lordship, nothing. My lord, I raised, my lord, I leave it to you.
लिखें। Your prayer is to consider representation because if there is no averment, it becomes magic. I'll come back in 5 minutes.
Complete.
লিস্টটা দেখি একটু, দুদিনের লিস্টটা দেখো, দুদিন লিস্ট। আপনি দিয়েছেন বলে তো হবে না, আপনি লিস্ট তো আগে হবে। কি আছে লিস্ট ভুল আছে, তাহলে তো অর্ডার রিকল করতে হবে। থাক, কালকে করবো। Yes.
My lord, item number 5, Mr. Bharat Chandani is appearing virtually, my lord.
May it please your lordships.
Today is unauthorized occupancy. Yes.
May it please your lordships, my lords, I beg to appear for the petitioner, my lords. My lord, this petition challenges the inaction on part of the revenue.
Your matter has not been filed. Mr. Rachandani, today is unauthorized occupants day. These matters won't be taken up today, Monday.
Monday, lordships may have it high on board, my lords, subject to lordships' convenience, my lords.
I couldn't get you. These matters are not taken up today.
Lordship, I understood, but lordships are saying that matter will be listed on Monday. I'm only praying it can be taken high on board because it's a refund matter. 3 orders have been already passed by your
It
lordships
will
in this
retain its
petition.
position wherever it is, unless other matters are added atop it. I don't know. Let us see what happens on Monday.
Lordship, please. Lordship, please. Great.
Can you please take care of the list? Some outstation council is appearing. You should always be careful with the list. Unnecessarily you have harassed him. You know it is not taken up today. Yes. Call করুন দিদি।
Actually alleging encroachment on national state highway, thereby blocking the ingress and egress of the petition. I have made a complaint in the month of August and September. Since nothing has been taken, my lord, I have people here.
Who is appearing for the respondent?
I have some, including the private respondent. Including the private respondents.
Service is almost 1 year back.
Admitted.
None appears for the respondents despite service.
The previous occasion, your lordship directed the state respondent to submit report and also directed me to serve the copy upon the private respondent. This is the affidavit of service.
But he is there for the state.
Mr. Santanu Maitra is appearing on for.
Yes.
Whether section 3 proceedings had been initiated by the SDO or not?
Yes. Should I pass over? Can you bring him?
I can call him at it, but perhaps he will not come. Not little our coverage.
None appears for the respondent despite service. It is noticed that
My lord, last question, your lordship. Please to direct the authority to. My lord, I have given notice to the private respondent also. The private respondent never appeared.
Private respondent has also been served.
My lord.
My lord, we have.
My lord, third time it is.
My lord, we have taken steps. Only 2 weeks, my lord, more required for affidavit. Steps has been taken, my lord. TLRO report, everything is there, my lord.
My lord,
We have
no
taken
demolition has been effected, my lord.
When will demolition? You have demolished?
My lord, we have.
No, my lord, nothing has been.
First page.
My lord, moreover,
requested the OT, my lord.
my lord,
Date for unauthorized, to remove the unauthorized construction, my lord. Date is 27. So, my lord, 2 weeks may be required.
my
for
lord, then it
implement.
be. Then let it be.
My lord, we are in the process, my lord.
Very well, I'll keep it after 2 weeks.
Yes, my lord.
Lieutenant, learned advocate appearing for then ওখানে none appears for the state respondents. None appears for the state respondent and the private respondent. Next.
For the petitioner, the last occasion your lordship directed to file
for the
specific report. They have filed 2 reports.
Yes. You are appearing for?
My lord, respondent number 6 private.
No, he is appearing for the state. Why is the state not here?
Supratim Dhar, earlier occasion he appeared as a senior advocate. Junior advocate is also there.
Should I pass over? You'll bring him.
Passover, it is available. What your lordship's my lord query.
See the report. The moment I give you a leverage, you want an order ex parte. That is not right.
No.
Ex parte order I will not pass.
3 days, my lord, they appeared.
They appeared on the last occasion.
Last occasion appeared.
Then,
but he did not.
They may be in difficulty. You also may be in difficulty someday.
Finally, see one, my lord, page 39.
Not required. I'll have to see the report first. I have asked for a report. If you want Passover, I'll grant Passover, or I'll have to make it not to be.
Not Passover. I will
bring them.
Yes.
Passover.
At 2 p.m.
Passover means Passover. Yes, 2 p.m. Bring them at 2. Seven 7:50. Yes.
Nothing in this matter. We have filed our written notes of argument and directed them to file their. Lordship, I give my and
One day prayer means if it is to be given tomorrow, it will appear today.
Yes, that's the only prayer.
Today means today night. I will be listing it only if I make it ready.
That's right.
So it will be in the list on the day when it is to be taken up as for judgment.
Yes.
In the earlier night, you will be able to know because this is all available online.
Right. Not in physical.
My lord.
Yes.
And today I have come to learn from the officer, my lord, they have made an inquiry, although my lord, he has been directed to file the affidavit in the form, report in the form of affidavit. But I have come to learn from the officer today, my lord, although they are busy in SIR, he has just told me they have made an inquiry, just he has paid for some days time more, because there is no encroachment of the government land, there is no, my lord, prevention of the egress. The petitioner has his own land and the privatization is his own land. All the report he requested. Well, then next week, well, I will file the report. Yes, yes, ma'am.
Mr. Guchai, learned advocate appearing for the state respondent time to file report in the form of full stop as requested. List this matter once again on when 5th.
Your Lordship, I appear on behalf of the petitioner. My senior is appearing virtually.
Milord, I am there, Milord, for the petitioner. Milord, this is that matter where, Milord, we are challenging the order, Milord, passed by the Milord landed district magistrate.
Yes.
Milord was hearing me. Now, Milord, the preliminary issue, Milord, that Milord I tried to canvass before your Lordship. That Milord, firstly, Milord, the order of remand. Milord, that has been. Milord,
This is something which goes to the root.
I'm sorry, Milord, I got disconnected. Milord, I'm so sorry. Oh, Milord, Mr. Bhattacharya has reached.
How is the appeal maintainable before the district magistrate? It should be before the commissioner. Because if we see section 7,
Yes.
section 7, an appeal from an order made under this act shall lie to the commissioner of the division by the collector, right? And to the collector, where the order is made by any officer specially appointed under subclause B of clause 1 of clause 2. Now this expression, an officer specially appointed under subclause B of clause 1 of, kindly take 2.
Yes.
Section 2. Section 2B means for 2.1, sorry, section 2.1a. Taken care of by 7B. A collector where an order is made by an officer specially appointed. If it is an order passed by an executive magistrate specially appointed by the state to perform all functions of the collector, then an order passed by this authority shall be appealable before the collector. In all other cases, the order will be appealable before the commissioner.
If your lordship comes to B, instead of the chief officer in charge of revenue, very first, the first authority, instead the chief officer in charge of revenue, administration of the district includes an additional subdivision. Manlo, please mute yourself. Yes. Includes additional district magistrate, a sub-divisional magistrate, and any executive magistrate specially appointed by the state government to perform all or any of the functions of the collector under this act. So, as far as this is concerned, the sub-divisional magistrate is the authorized person. No, I'm coming to that. I'm coming.
Any executive magistrate specially appointed by the state government, this limb of section 2.1b answers section 7b, an officer specially appointed under subclause B of clause 1 of section 2. The other limb of subsection I mean clause B of subsection 1 of 2 pertains to a different class of officers. This is the only class of officer which is appointed by the state government to perform all or any of the functions. Now, an order passed by this officer or a class of this officers will be appealable before the collector.
Yes.
So far as the other officers are concerned, the appeal will be before the DM, before the commissioner.
Yes.
Now, in this case, the order has not been passed by the executive magistrate. The order has been passed by the SDM. If the order has been passed by the SDM, then he falls in the first limb of clause B, and by dint of that, the appellate authority will be the commissioner, not the DM, not the collector. Because collector includes within its fold two kinds of officers. One is one which has been specially appointed.
Man, this takes 2 minutes of a lot to say because your lordship has gone through. I'm just trying to section 2, the definition of collector.
Yes.
Collector. So that means first in Calcutta you'll have to link that B. Elsewhere, the chief officer in charge of revenue administration of the district and includes an additional district magistrate, subdivisional magistrate, or any executive magistrate specially appointed by the state government to perform all or any of the functions of the collector under this act. So this order is passed by the sub-divisional magistrate.
Yes. So it is not an order passed by an officer specially appointed by the state. Let us understand it in this way. It can be an order passed by an officer otherwise than an officer specially appointed by the state government to perform the functions. This is one. The definition, Mr. Banerjee, if we dissect it into broad subdivisions, one will be an officer who is specially appointed and another will be an officer otherwise than specially appointed. Now, in that otherwise section, the chief officer in charge of the revenue, additional district magistrate, sub-divisional magistrate will fall. So far as specially magistrate category is concerned, the executive magistrate will fall. Both of them comprise together collector. But against the executive magistrate's order, the appeal will lie before the other limb. So far as the chief officer in charge is concerned, additional district magistrate and sub-divisional magistrate is concerned, the appeal will lie before the commission.
This gives it 2 minutes. Let me just.
When we address your lordship, PC page 493, volume 4.
Four nine three.
It will be volume 4.
Didi.
Stop reading. I'll take an annex question. Annex
493. Four nine three.
This is the document Lord, seeking my removal. Bhagwan Das vehicle test, it was addressed to.
My lord is on this.
No, but after this, the show cause was served on me. This was addressed. Copy.
Let us first have this issue. My learned will be argued. Your lordship is not. Let us get into this. But then not let my learned.
No, not that.
Hijacking, I don't like.
Mr. Bhattacharya,
Not hijacking, just to assist him. He is client. His client. If your lordship sees, page 496, copy giving to additional district magistrate.
Yes. How does it matter?
And the authorities thereafter serve on me to the SDM and the proceedings.
That is precisely my question. My
That
question,
is
Mr. Bhattacharya.
As far as SDM initiating, your lordship does perfect.
SDM initiating the proceeding,
But
that's not a problem.
your lordship is the appellate authority. Who tells?
Appellate authority, DM will not be the appellate authority is the issue. The appellate authority will have to be the commissioner if the order is passed by the SDM. That is how the section reads. If you read section 2.1, read section 7 first, because Mr. Banerjee has gone through it.
Yes. May I just take it one by one?
Yes.
Now let us see who is going to be the appellate authority.
Yes.
An appeal from an order made under this act shall lie to A, the commissioner of the division where the order is made by the collector. This doesn't apply. Next is to the collector where the order is made by an officer specifically appointed under subclause 3 of clause 1 of section 2. So where it is an officer under this section. Now, if you look at section 2,
yes,
who are the officers under this section? Specially appointed. Over there is collector means includes additional district magistrate. He is also an officer appointed under the
not specially appointed
No,
category.
may I say all of them?
No, Mr. Banerjee, if you read the language of section 7, it says an officer specially appointed.
Yes.
Now, an officer specially appointed is again used in
Under which section?
No, it is specially. The expression itself is used in 2.1b also.
May I just put it? What has it been? According to my humble submission, if your lordship sees the
appellate authority, the appellate authority refers to whom? The appellate authority says that it can hear any appeal from an person, from an order from a passed by a person who comes by anybody specifically appointed under 2(1), whatever it's under section 2, let's say. It's any of them. It may be.
But Mr. Banerjee, under 2(1)(b), specially appointed is there. It's there in 2(1)(b). This very expression has been.
All of them are the same classification.
How can we club the other officers who are not specially appointed as one specially appointed under 2(1)(b)? Then there has to be a notification.
Well, may I humbly submit? Today, as far as section 7 is concerned, 7 does not say specially appointed by the government. Section 7 does not say specifically appointed by the government. It says specifically appointed under section 2, not by the government. The various classification under 2 has one classification is appointed by the government. That is one. But there are other classifications also.
But that is left out of the purview of 7. Then the appeal lies before the commissioner so far as others are concerned.
No,
because Mr. Banerjee, let us read 7.
Yes.
An appeal shall lie from an order made under this act shall lie to A, the commissioner of the division.
Let us forget that.
No, it's important. We can't forget that. Where the order is made by the collector. Now, this expression collector includes within its fold several officers. Now, this expression collector also includes additional district magistrate, subdivisional magistrate, and executive magistrate specially appointed. Now, if you have a plain reading of this, if you exclude B from the purview, then all the appeals against orders passed by any of the authorities under 2(1)(b) would lie before the commissioner. But for section 7(1)(b). So 7(1)(b) carves out another category of cases where the appellate authority will be collector only if an order is passed by an officer specially appointed under subclause B of clause 1 of section 2. Now, this an officer specially appointed under subclause B of clause 1 of section 2 is exactly copy-pasted from 2(1)(b), where officer, any executive magistrate specially appointed by the state government under clause 2(1)(b). How can we divorce that?
May I? My humble reading is the collector, when I'm looking at reading at 7(b), the collector where the order is made by an officer specially appointed under subclause B of clause 1 of section 2. Appointed under subclause B of clause 1 of section 2. Now we have to go back to section 2.
Yes.
When we go to section 2, who are the people who are appointed over here?
No, Mr. Bell, they are not appointed. They are already included. Because specially appointed is only one person, executive magistrate.
No, the word used is collector. Collector is defined as various things. There is a classification, includes the additional district magistrate. He is also appointed as a collector. He is also included under that. The subdivisional magistrate is also treated as a collector. These are the officers who are specifically appointed under this act to act. It does not say, section 7 does not specifically limit it to the officer appointed by the government. It says everybody who is appointed under the section 2(b).
Mr. Banerjee, it also becomes important in the wake of this. If you see, in section 2(1)(b), this expression executive magistrate specially appointed by the state government was there. This executive magistrate portion was inserted by an amendment of 1976 instead of officer not below the rank of magistrate of first class. And this led to because the collector includes all. And this point will fall for Mr. Bhattacharya also to answer because his appeal will be incompetent before an authority who is not authorized to hear the appeal. Not only the order.
No, both of us have to answer. There's no good. But I'm trying to explain your lordship, like, my humble way, Milord, that today, as far as the first authority, your lordship, there's no problem.
There's no problem because
because that it comes within the bill. But the next is your lordship says when it has
no,
to
the
be
first authority, chief officer in charge. My reading of the section is chief officer in charge of the revenue, additional district magistrate, subdivisional magistrate. Up till this, appeal will lie before the commissioner, and the other authority, executive magistrate, specially appointed by the government, which is the expression used in section 7. Appeal will lie before the collector. That is the DM. Or it may lie before the subdivisional magistrate also if the subdivisional magistrate is the collector.
Huh?
Because for the purposes of this act, all of them are collectors.
Only problem then is because under this your lordship is using.
Because then Mr. Banerjee, so that you can answer this question also.
No, I like the fact that your lordship is expressing a lot of minds. It helps us to understand also.
Section 7B will become OCOs if all the appeals are to lie before the DM itself. Then in that case, you are sorry, section 21B, you are whittling it down to mean only district magistrate, because only against the district magistrate's order an appeal will lie before the commissioner, and against all other authorities it will lie before the district magistrate. Yes. How are we reading that? How? Because the collector includes within its all the authorities.
Not commissioner of the district.
The collector of the district. Definitely not. No. Therefore, the appeal against the collector's order will lie before the commissioner. Appeal against now every collector, a collector includes within its force the chief officer in charge of the revenue also, the ADM also, the SDM also, and the executive magistrate specially appointed also. So, what is the reason for us to hold that so far as the appeal against orders passed by subdivisional magistrate and executive magistrate are concerned, those will lie before the DM, and only for the DM it will go before the district before the commissioner, because collector is one. Only defining factor therefore means specially appointed under clause 21B.
Section 2 does not define commissioner.
No. We'll be whittling down one part of the provision. That
Okay.
हैं तेरे रिव्यू की only thing, I'll tell you, this is a serious question.
Yes, it is.
I will, in fact, I want, because I can give an answer now, Milord, that be off the cuff. I want to look into it and come back and assist your lordship properly.
If there is any other mode of notifying.
Yes, whatever it is.
It can't be like.
I don't, Milord, at this stage of my life, I no longer want to talk nonsense before court. So that's why I'm telling you, Lordship, let me, if I can come up with something concrete, I'll come and tell you. Lordship.
Yes.
Only see section 3.
3 years.
And if you respect of any public land, the collector is of opinion upon application made by an officer. Every year. It doesn't use any other word apart from the word collector. Yes, the word collector, as very rightly pointed out, by your lordship as well as by Ganesh senior friends. Please see section 2.1. Collector in Calcutta means something. Elsewhere, the chief officer in charge of the revenue administration of the district and includes an additional district magistrate, a subdivisional magistrate. He is the collector in the particular district. And in case, why was the appeal presented before the district magistrate? Because since the collector were the subdivisional magistrate is the collector. Subdivisional office. He was acting in the capacity of a collector. He was not specifically appointed by the state government. He was by virtue of the definition. So, what we are on, what I am trying to be emphasis on is this appeal from his order would lie before the commissioner of the division. Where the order is made by the collector. Collector in the context of this provision 7(1)(a) is subdivision. Now, the commissioner of the division, my understanding and I have to produce the document. This is Agarwal. Ms. Agarwal says, there is something. The commissioner of the division is the BM. In the district.
That's exactly what I want.
That will solve the problem.
I want to take that in.
The state government, perhaps will be able to assist your lordship.
Otherwise,
it becomes, OCO.
It becomes difficult.
No, that is
one part of the section becomes meaningless.
That is why I want to come back with that.
I think, the state will be able to assist. The state.
It should be because this point cropped up in another matter.
State is supposed to bring it. How are you doing it?
This point cropped up in another matter today morning itself.
No. What your lordship is saying, I think we should get. I think what my lordship said is absolutely correct. Possibly the commissioner and
that notification is there. That can help.
I think there is something because this is perhaps not the first time that this issue is cropping up. There are innumerable situations. It must have cropped up somewhere.
Being lodged before the district magistrate without any objection.
Perhaps the commissioner of the division, where the order is made by the collector. In the context of this, collector is not the DM, collector is DM, subdivisional officer.
That's not doubted at all.
State government,
not doubted.
the state government should inform you.
the person initiating is not in doubt.
No.
But the person before the appeal is made in doubt.
No, Milord, why, Milord? Show cause for this. Just 1 second. Milord, so that, Milord, the position becomes clear.
No, that I have understood, Mr.
No. Just one thing. Milord, no, এটা না, যেটা কেটে দিয়েছিল। হ্যাঁ, এক্ষুনি দেখলাম। Just give me 1 second. Milord, page 4. No, এটা না।
Page 4.
No. Milord, there is a document where the first focus was served by the SDM. SDM, exactly borrowing the language of section 3, described it. In section 2, your lordship will only find the word collector.
Section 2.
In section 3, issue of notice.
Yes, collector. Yes.
Collect. Yes. In the first, I'll demonstrate before your lordship. Here, chop off
the portion that has said on information being laid. Correct. That is why if it is the collector, the appeal will lie. And collector, Mr. Bhattacharya, collector also includes within its scope the executive magistrate. The collector,
Not all executive, but
specially appointed.
How I would like to, but again, I'm saying making off the cuff. I'll have to check whether the circular is there. But my statement is, as far as sub-divisional magistrate, additional administrative magistrate, they all come within the meaning of. But for an executive magistrate to come in, he has to only specially appointed.
Correct.
So therefore, not all executive magistrates
The point can be solved if there is a circular.
So if there is something to that effect,
I have come across it for the first time. Mr. Shakusen argued it today morning. It was an interesting point.
No, sir, we have to clarify it for you. That's why I said, let me not do a off the cuff.
No, he's observing it. Very well. He has to fix the date. No, we'll have it on Thursdays. Thursdays only. Fifth, I will.
Kindly keeps it on 12th instead of 5th. My humble prayer. I leave it to your lordship.
No, this can happen only on Thursday.
Yes, because the other days there are so many determinations. Revenue.
11th, 11th.
12th, not
11 না 12th হচ্ছে 12th বৃহস্পতিবার 12 তারিখ
12th
12th মানে
last order needs to be extended.
মানে সেম অর্ডারটা পাস করতে হলো
তুমি চিন্তা করো না নিয়ে আসে চিন্তা করিস নি But I'm not in town on 5th. That's the problem. I know it, but that is getting delayed.
At least 5th is not on me, Malad.
Listen. Heard Mr. Bhattacharya, learned advocate, appearing for the petitioner, and Mr. Banerjee, learned senior advocate, appearing for the respondent number 6. Respondent number 6. Full stop. As jointly suggested by the parties, list this matter for further consideration on February 12, 2026. Full stop. Since the hearing is continuing, comma, the subdivisional magistrate is postpone the hearing before him on a date later than the date on which this writ petition is made returnable. Yes. I'm recording the same thing.
Yes.
After that,
obviously, when you learn to hearing, it is no question of the matter will assume a lot of significance. Once the matter proceeds to the next stage after this issue is clarified. Only one. According to me, after so many years, no matter who goes anywhere. Only one thing. Have you not direct the state to produce any notification? No. You have not to take instruction on the matter. They are actually the authority. I try to get
on the returnable date, comma, last paragraph last paragraph on the returnable date, comma, the state respondent shall clarify as to whether there is any notification notifying the district magistrate to act as the commissioner of the division under section 7 of the Public Land within bracket Eviction of Unauthorized Occupants Act, 1962. Okay. Not done. Listening. Learned advocate appearing for the petitioner seeks leave. Learned advocate appearing for the petitioner seeks leave to file the reaffirmed amended writ petition in terms of the order dated January 15, 2026. Such leave is granted. Full stop. Copy of the amended writ petition, reaffirmed amended writ petition, has been served upon the learned advocate preparing for the respondent. Full stop. List this writ petition for hearing on February 12, 2026.
Obliged.
What is this CAN 1 appearing for in this?
That was the amendment application which was prepared. That was disposed of. That was disposed of.
Where was disposal of already named?
No, my lord, that was not.
CAN 1 is allowed. What more? What more disposal? CAN 1 allowed रखा है तो कैसे में रखा है?
In third paragraph, it was disposed of.
लिखे नहीं तो direct order. लिखे नहीं. Actual line लिखे नहीं. It is recorded that CAN 1 of 2025 was allowed by the order dated January 15, 2026. Full stop. Since CAN 1 of 2025 stands disposed of, comma, the same is wrongly indicated in the list. Full stop.
Your Lordship,
Give your name. Give it. Give it. Yes. Seven. Actually, the parent, you are a parent.
the learned advocate appearing for the petitioner is not here today due to some personal difficulties.
Not today.
Yes.
Not.
Obliged.
Next. Yes.
My lord, I appear on behalf of the petitioner. My lord, this is the second round of litigation. So, my lord, I have come before your lordship for implementation of the order passed by the Honorable Court earlier. So now,
Where is the order?
my lord, order dated page 17.
Yes, sir. Order. What has happened?
My lord, my lord, may I clarify?
That I have understood.
There is instruction to me. Extra copy extra there. My lord, kindly give the direction upon.
This writ petition complaints of inaction Give a copy, give a copy.
I'm for the respondent number 3, madam. GPS.
Give your name.
We will come back in 5 minutes.
Yes. Other side is there.
And ask them to appear.
They get to order these. Click. None appears for the respondent.
Plan for the the petitioner is the owner of a plot. Petitioners, they are the owners of a plot. They have made their residential building on in terms of the upon compliance for all required formalities. Private respondents enclosed the government land and constructed house, temporary house in front of my building. That's why I have made several complaints. No steps has been taken. Last representation is the 18th August 2025. This is the last representation. What steps they taken, only one of the state respondents can say.
This is a very good step. I have for this step, Madam, I have discussed in inspect and those that it's not relevant. That is from the police authority. Regard to the construction and on consideration and representation to the instruction and report. Highway commissioner. So since there is a representation, will have the is appearing for the private response. They're appearing for issue that private response.
One of the service has been effective,
That is September.
Yes, then
Sir, again, I'll hear it from the none appears for the respondent number.
Respondent number 10,
This is the government leader saying that on the next occasion, if they don't appear, consequential order will be passed. That is what I have said.
I asked my learned junior to
Because it was in the
pray for
morning.
time. He rang me up. He said he is suffering from fever, so he could not give me the papers. I said, without papers, how could I go? And then he gave me the assurance that he would be praying time before my Lord. And then I got to know that he never appeared at all.
Yes, no, in the morning nobody appeared, so I passed it.
Now he has switched off his phone. My apology for that.
No, not at all. Yes, next.
Appearing for the petitioner. The last occasion, my lord, in this writ petition, I have prayed for the conclusion of the proceeding initiated by the SDO concerned.
Yes, yes.
Person,
He appeared. He argued
yes,
very nicely on the last occasion.
yes, yes.
He held
Now,
what happened in the hearing?
My instruction, thereafter 2-3 hearings date was fixed, and the concerned SDO directed, requested the BLRO concerned for demarcation. But the demarcation could not be took place. In one occasion, BLRO appeared. BLRO to take steps, took steps for demarcation, but due to some obstruction by the private parties, that is not done. So,
So that means proceedings are continuing. I'll direct them to.
Yes.
I'll direct them to conclude.
Conclude,
in a
yes.
specific time.
My lord, one thing, my lord, last occasion, my lord, 9th January 2023, BLRO forwarded later, my lord, where, my lord, without LMF, my lord,
They will
whatever may be, the demarcation, the authority is the BLRO concerned. They will
this repetition has
Yes. My lord was directing me to serve again, my lord, I am sharp. My lord, yes, with a bit of service, and my lord, we are about
State.
Very, very, very good service.
My friend from the state.
You are appearing for?
State.
Earlier, EBDB service was 5, my lord, this is the second time, my lord, he has notice of staff, he intimated them, and my lord, you will also kindly see the top, all of them, my lord, received. My lord.
No, but this you have not brought on record by way of an affidavit of service.
That was one of, this is not an evidence of file, my lord. There is earlier evidence service of file, and this is the second time, it was not, after affirm is not done.
After press service, you will file an affidavit of
After
service.
my first time, I filed an evidence of service, this is the second time I filed.
This can be direct of
What is
dispose
this then? This
dispose of
representation.
representation.
Which day? These are all 25, 24. How can they be in the state?
No, my lord, that was not, this is already lots of directed me, my lord, this is already latest one, my lord.
So you are handing up affidavits of service which date to 25, 26.
No,
The 24, 25. My order was of 15th of January 26. How can they relate to this order?
No, that was subsequent on 15th of January
So
2020.
give me that only. Why are you giving me things which are predated? That is the answer.
The earlier evidence service is dropped. 15th of January 2026.
You have form an affidavit today in course of this day you file it. Otherwise I will not sign the order. Listen. File affidavit of service.
Lord, I am appearing on behalf of the petition, Lord.
Yes.
What has actually happened, Lord, before I make this amendment, I have submitted to file section. Lord, this case is a very tragic case. Lord, the position is this, Lord. The petitioner, who happens to be an engineer, Lord, he took leave of the Calcutta Port Land. And Lord, that leave was applied in 1974 and it expired in 1997. Is engaged or he was engaged in manufacturing of chemical that things were going very well, there was no problem. In 1997, Lord, since the period of this expired, the state officer gave a notice under section 4 a lot of no. My client entered a very contested, and as usual, Lord, I have seen in my opinion that before the state officer notice, Lord, he blocked it. Then he Lord, that section 5 is there, then section 9 application. Because appeal like this process. Lord, it will appeal still lodge. Lord, before the High Court, Lord, so the matter was moved from one court to another. Different courts have protected the interest of compliance. And Lord, if I say, Lord, the Honorable Justice Common Sense and Honorable Supreme Court, they were pleased to pass from time to time. And I was asked to deposit 1 crore something towards the rent. That has already been deposited. I have received copy of the receipt. Lord, even then, Lord, says that is not satisfied. Lord, what they have done, they put some Lord that order in the meantime, what has happened, I can be very frank, the Lordship has seen this Lord that application has become very much waiting. For the reason, Lord, I have disclosed all the facts right from the verification. Why do I? Lord, two applications have been moved to the revision. Lord, that additional order passed excellent two applications. Two applications, unfortunately, was refused for the point. I'm not clearing the valid advocate, substantial legend advocate. I will accept copy. Application for a special possibility. I'm afraid that I have to resolve. But in the meantime, they have started the execution process. And in that execution process, I entered again. If this development is 50 cases, I entered again from the big I have been contesting. Then a report was called for by the judge from the Calcutta Port Trust approaches. They have filed a report. And in that report, they say that the exercise of the power in the section 6 of the Act, Lord, they have taken possession of my state. Lord, the goods of Lord, crores of rupees of the defense were like there. Lord, I was not given in proper notice concerning the shop. And Lord, they took symbolic possession, or rather, they say that we have given notice at the premises, that is at the factory premises, not at the registered office. I will accept copy of the report also. Lord, from that report, that is to be Lord, that we have not been provided with the proper opportunities. Lord, I have made the representation before the authorities that the full thing should be brought to Lord, should be clear, because there should not be any ambiguity. Lord, your plot is coming to that for a moment. Director. Lord, has got a copy of the report. Section 6 is also condition.
Yes.
Lord, disposal of property left on public premises by the owner of the hospital bank. Losses is very much other Lord, that even under the public demand Act or under DRT Act, Lord, that when an option, the property is put on option, opportunity is given. Yes, that is content. Where any person has been registered from any public premises has not been registered. Under section 5 of any building or other work has been demolished. The state officer may, after giving 14 days notice to the person from whom possession of the public premises has been taken, or after publishing the notice to at least one newspaper having circulated, remove or possibly remove of by public auction any property remaining unsuccessful. They are not exposed to property on auction. Where any goods, materials, cattle, or other animals have been removed from any public premises under section 5A, the state officer may, after giving 14 days notice to the person claim that goods, materials, cattle, or animals, or after publishing the notice in at least one newspaper has been circulating in the locality disposed of by public auction, such goods, materials, cattle, or animals. Notwithstanding anything containing from section 1 and section 1, the giving or publication of any notice referred to in therein shall not be necessary for the respect of any property to subject to speeding and equity. The question of immediate electricity is order as regards to the individuals. Decay. And the state officer may, after recording such evidence as may be paid for property to be sold otherwise disposed of, that is not allowed. When any property is sold under subsection 1, the state office, whereas shall after deducting the expenses of the state and the amount of wages due to the central government or the state authority on account of areas of gain or damages or cost to pay to such person or persons as the adherence to the state officer to be entitled to the state. There is no compliance of all this. The state officer is unable to decide a person or persons to whom the balance of the amount is payable or the apportionment of the same is made. Refer such to the report of compensation system and the decision of the are both whereon shall be standard. These provisions have not yet been supplied. But whatever might be brought, because I have taken that one, I have mixed a report also, which they have submitted report to consider it, decision, that report I have released. Lastly, Lord, having found that nothing is being done, my client made a representation, Lord, P46 it made a representation. The report is there. There after the report. He made a representation that P58, P60. That is 18th of November 2020. And since then, matter has been pending, nothing has been done. The factory is again closed. Employees have been thrown out of employment, and though I have been paying that provident fund, etc., all papers I have with the expedition. What I am humbly submitting to such sort of matter, and the different certainly opposition able to do that. But the thing is, my humble submission is some of the things. Look, my representation dated 18th November 2020, which have been made to the Board of Trustees of the some of the voters. That will be disclosed to your lordship's consideration.
Why not? Because, my lord, I have no nexus with this petition. Original list is the Crepe CI Limited. Original list was there, my lord. The eviction order was passed. Several appeal was filed. Section 9 appeal was filed. My lord, writ petition was filed.
Page 338 is about crepe manufacturing only.
Yes, crepe manufacturing. Yes. That is in this the original list. Here is the crepe CI. Now, that is an appeal in the. He has prepared an appeal. That is 332, my lord.
338. That was properly posted, not written. No. That is there. My humble submission before you, please.
Representation has been made. Why should it not be considered?
Okay. No, my lord. What happened? Here is my lord, suppression of fact. All are suppression of fact. After the appeal was filed, the appeal was dismissed. He filed a miscase for restoration of the appeal against that eviction order, my lord. In that eviction order, Section 5 application, the learned district judge directed to file a report. What was thereafter? What happened?
This representation has been made by the petitioner, and the appeal was filed by some other person.
No. He has filed appeal. He has filed appeal. Look, he has been inducted by the Crepe CI. Crepe and Crepe manufacturing, they have preferred an appeal. Your lordship, kindly see the appeal order currently. Crepe manufacturing. Crepe manufacturing, the petitioner, they preferred an appeal, section 9.
Where?
I am showing, my lord, that the report has been filed here, my lord. 332.
But it's
report miss case 831. 332.
May take your lordship to the report. But the return
then after you are finished, let you finish, then you.
What
report.
is the harm, Mr. Jana, in considering?
No, my lord.
You say the same thing.
No,
you are saying.
I am saying, man, everything has been completed. No, my lord, you can hear me thereafter, your lord, I will found out what happened, you know. But these are the representation of the fact, my lord. After that, this report was filed, the appeal was dismissed. He has not enclosed. Appeal was dismissed in 2018. What remains? And goods have been auctioned, sold, and my dues is 39 lakhs, 39 crores. What he is asking for, my lord? What representation? The matter pending before the estate officer. Estate officer passed his final order, challenging that final order. Preferred an appeal on the.
Show me the order, because
Section 5.
You said 2018 something was.
Yes. He has not produced, he has not disclosed that he said the appeal is pending. And you see the prayer of the writ petition?
Please not use your words, not your thoughts. Use your words. So that property has been auctioned and this is the land which has been taken.
You are equal to lordship, your lordship's judgment one. Considering the APL in India with Supreme Court judgment one. I'll show it to your lordship.
I am also
On the similar point, your lordship decides.
I am also able to
Considering whoever the property is lying there, I have a right to sell it. That is the.
You have the right to say, but you are accountable for the state conflict.
Let him go before the estate officer.
What is the difficulty in this political presentation?
He is not a simple case for representation to consider the report. Otherwise, I won't oppose that.
This appeal was filed by whom?
Petitioner hearing
to dismiss.
Yes. What remains?
No, there's no, it can't be restored. It was dismissed on the ground of section 5 limitation.
Yes.
No, but Mr. Rai, if your appeal itself is not there, what more representation will they consider? They cannot give life to a dead proceeding.
What will be recorded, and giving given opportunity for hearing.
But Mr. Rai, for what? Your case has been considered. Your case has been considered by the estate officer. The estate officer has passed an order against that you have preferred appeal. The appellate authority has dismissed your appeal.
Against that order, we have
No, what has happened to the civil division?
I have reached the office of the civil division.
Against which order? Against the order dated October 2018. Please show me that.
The auction has already been completed. Following the section.
Okay, then.
One civil division is of 2015, so this will not be against the 2018 order. Then
Let's can number your lordship kindly say that copy was your proposed. This copy of the case
Several judgment, my lord, even if your lordship, division bench, coordinate bench, on the point of section 6, my lord.
His submission. One below COs are there, page 173 to 79. 173 to 79. COs are there.
2015, what management bench?
Have also been made.
2015.
but these COs cannot be against this order, Mr. Rai. This order is of 2018. CO of 2015 will not be against an order of 2015. Huh?
After 2018,
After 2018, there is no CO. There is only one CO and that is of 2015.
2015 is there minute.
Now, how can it be? He submitted that the appeal is pending in his writ petition. Yes, said appeal is pending. I'll show you the abarment manner. How can be that? Appeal is pending.
An application has been filed.
Yes,
2017,
para 57.
That is 289.
Para 57.
In and lawsuit sanity.
Page 36, para 57.
Look,
No, Mr. Rai, please see page 36 of the writ petition, paragraph 57. What happened to this appeal? Where is the averment as regards this?
831, logically, must be 831.
Sir, P14, it is P14.
This order is 831.
Page 31. Page?
That is the report.
Yes, but this report is of no help anymore because your appeal has been dismissed. After dismissing of the appeal, they have sold it, is what he's saying.
Yes, I will let my instruction, you will have to record that. We have sold it.
You bring the instructions on the next.
I have an instruction. Sold
So
it.
that
So written in. So,
if he has, I'll record that then.
I think it. Only the thing I put. I have an instruction. Yes, ma'am. One instruction. I have to copy it. Yes, section 6 compliance is there. Compliance there. Section 6 is compliant. At what time? But a easy case whether the section 6 has been compliant or not. That is the subject.
What is your prayer in the petition?
That stay of this report. This report was filed. Why he filed an application for under section 5 for restoring the appeal, recalling of the appeal. In that application, there is a direction to file a report. That is the report.
And this might be. For the not to be for the action of the response
Report. Where he 332.
Please telling out the property to the company. I'm saying that they have not sold the property.
No, but they say they have sold it, so you'll have to challenge the sale now.
Let them keep the copy of the report that they have sold it. I'm certainly challenging it.
Well, your lordship kindly record my instruction that the property has been sold in auction. I have received the auction money. After adjustment of the auction money, 39 crores is due. That is my instruction is there.
No use, Mr. Rai, if they have sold
frivolous
it.
application.
If they have sold it, they will, they must have you not published it in newspaper?
Yes. It was published, notice was given, 14 days time was given.
Very well. On the next date, you bring your instructions. I'll record all of that. He will also be satisfied. Then we can. I'm recording your submission. I'm recording that.
I'll come with the necessary instruction as to the section 6 proceedings.
This writ petition has been filed
Okay, very good.
Next.
Actually, I have a report indicating that the present status of the application of lease is concerned.
No, I had asked for a report from the state to show whether the petitioner has been heard or not. Your lordship. That is why I have asked, and I have asked you to file the report indicating the status of the petitioner's application for grant of leave. I couldn't understand. I couldn't find it.
In terms of the court order, but I am not prepared report. Thereafter,
You have produced, you have got your report in terms of the earlier order or not? Preliminary or final, I don't know. Is it a report in terms of this order or not?
without reply, no, I am not confident to.
When will you be able to file?
Other than, No, no, no. So, moderator have to ask. Okay. Yes. All right, okay. That's all. Look, this is a second round of litigation, Malad. Kindly come to page 27. But initially a requisition was filed, alleging that there was encroachment on the national highway. A requisition was filed, there was an order, the respondent number 10 was directed, that is the project director was directed to remove all the illegal encroachment. Now it was done. Thereafter, after 15 days, again, the same person, they have once again encroached some portions of the national highways area. And the land which belongs to the irrigation department. The entire locality bill of the entire of that place, they could not even get into the main road due to such illegal encroachment by in the land of the irrigation. So I made a representation before them. That will be considered by the authority, LGO, that is a sub-division. Put me what is the report? There is no necessity of report as because in spite of that, we have already got that report, we have already asked the BLRO to demarcate the land. Last, that is the 6th. Can I get a copy of it?
Yes, they have been directed to conduct field verification.
Yes, after verification,
they will take appropriate steps.
Yes, my lord. According to the no, my lord. Thank you. Paragraph 1. The second website that the importers have been identified as St. Museum, St. Nagar, St. Tagore, who are presently running stock committees to forward. So now it has been identified. So now the process is this they have to be evited.
But the demarcation has to be done.
Once field verification was there, my lord. Already the process for removal of the unauthorized application from the government land.
This has been done without demarcation. They will have to demarcation then because the areas have to be.
Yes, my lord. That can be.
This
85 your lordship will take up to your correct.
Kindly.
Anyway, my lord.
Interesting matter, section 6. Section 5.
Notice, goods has not been delivered.
May I?
There
is a previous order made by the Lordship Court. Apropos that, the authorities have passed an order which is under challenge for its Kindly see the order under challenge. So the first previous order is page 3940. And let's please come to 42. Yes. So we are specifically, Milord, at page 42, the last portion it begins. Yes. The PVP of contract is waived. And Milord, please see page 43. P it mentioned, when the paragraph beginning with P it mentioned. Yes. Thereafter, by the order dated this, to initiate steps for disposal. As a matter of fact, a right has been accrued in favor of the SNPK for satisfaction of its claim in respect of premises in question by disposal of goods articles held by an authorized officer to the premises. Therefore, release of these goods articles cannot be allowed without satisfaction of SNPK's claim in question. Further, as the main objective of section 6 is basically to make available some amount as will be available to the sale proceeds of the deduction of cost of sale, including engagement of valuer, etc. I also cannot consider any matter regarding release of such goods in absence of any appropriate application from SNPK scale. Side. Moreover, the applicants herein are all rank outsiders, etc. With the above observations, the applications dated this and accordingly disposed of. However, the insurance applicants interested are at liberty to take back their by way of participation in the auction process. Similarly, they are relegating me to an auction. This is the nature of the order. Their materials why are you not releasing? What is the problem?
What is the problem, Malad? This issue has already been decided by the Supreme Court as well as by your Lordship and other coordinate bench and division. I will show one by one judgment. Under section 6, whoever kept the goods in the premises, I can sell it by an auction. Right? He has no, I have no nexus with him. He is a third party. The original tenant is someone else. Somebody has been inducted to put the goods in the premises, Malad. So I have a right to sell the goods. That has been an APL India judgment, my lord, and that has been quoted by your lordship in another matter. APL India judgment, my lord, your lordship can see that judgment. That has been considered by your lordship. Division bench of this court.
He is relying on 1914.
Yes, 1914.
I have got all. You have to follow the
APL in. Yes.
Let him take it in his own.
Today or
let's have it next because the original side will have it.
Next, sir. Other judgments are there. Your lordship judgment there. Division bench judgment there. Similar circumstances. Yes, similar.
When did they approach?
They have approached. That has been initially during the vacation, my lord. They approached Honorable High Court. Honorable High Court said, I know what you want to say. So, Honorable Court says that during vacation, let them approach before the estate officer to consider. They have approached before the estate officer consider. Although he is not entitled to consider, since the court has passed an order, consider because following the judgment of APS, and you have to pay the entire decretal dues of the original list. Then good can be released. Otherwise, that is the law. That is the law. I'll show it to you.
So, Mr. Bhattacharya,
Contemporaneous law, contemporaneous
after the conclusion of sale, the auction sale was completed thereafter. Even.
There is no auction. There is no auction yet. That is a different issue. Whether I have put in auction, whether I shall release these goods or not. That is the question here. Whether I put in auction, I have to release or not. That your lordship decide. Thereafter, the question of auction. No. No.
Mr. Nag, assisted by Mr. Jana. The affidavit of service, please. Yes. Affidavits are complete. None appear for the petitioner. Affidavit in opposition filed on behalf of the respondent. Yes, but this petition challenges a notice under section 148 of the Act for Assessment Year 2019. Yes. So if my lord will just see page 333 first. 333. This is my computation of income. Yes.
So you see, I start with my income as per profit and loss account, and I add back various items. Now, if I now see item number 3, exceptional item debited to P&L account, 35.20 crores. Yes. And item number 11, donations and CSR expenditure during the year, 4.15 crores. When I claim a deduction, so now this is the second last row, deduction under HPG of 2 crore 18 lakhs. Right at the bottom, second line. Yes. Yes, this return was initially assessment was completed under section 143(3). So that thereafter,
only my one preliminary submission before we got the affirmation of affidavit, that it is affirmed in Haryana by perhaps notarial service. Second thing, the preliminary to subject to office correction. This is a Horish Chawla. I am the director of it is his statement. I am director of Philips India Limited. Now I do not find any the resolution of the board, and your lordship knows that without the resolution of the board, that I do not know.
that must be there with the
Happy.
Yes.
And we got the affidavit regarding
affidavit if he is outside the state, why cannot he? Affidavit if he is outside the state, in the last matter he was within Calcutta. Here the address is outside Calcutta. Gurgaon, Haryana.
Yes, Gurgaon, Haryana, notary has been done of Gurgaon.
Yes.
But our rules will are perhaps does not
that notary has to be done in Calcutta. That is notarized. It should be notarized.
Notarized, but then says the chapter 15 says it will be 5 radius kilometer of the area.
Not for affidavit, not for notarized.
Then I am
Yes. Yes, this original assessment was completed. Thereafter, we discovered that certain employees had made a fraud on the company. And there was certain expenditure which was booked was not genuine. So I suo moto went to the department and I said that I'm filing a revised computation disallowing this expenditure which I have discovered subsequently. To give effect to that disclosure, was another 148 notice was issued. And pursuant to that also an assessment was completed, where again these two claims were not in any manner disputed at all. So twice considered. Then a 148A1 notice is issued. Now please see that notice. The 148A1 notice, my lord will find, is at page 487. This gives rise to the present 148 notice. 487, 487. Rest of 223. Yes. Whereas as information which suggests that income chargeable to tax has escaped assessment within the meaning of section 147 of the Act on account of the following. Information in accordance with the risk management strategy formulated in this regard. And that was enclosed with the return which the law will find at page 488. And information was flagged on the verification mode of the inside portal under the category of high risk information wide number 10. So the case of the associate executed on the basis of the risk parameters thereto approved by the board risk management strategy sacrifice for the identification of potential cases of actions under section 148, 148. The information and material relied upon attached with this information suggests that the SSC company Philips India Limited had claimed expenses to the tune of 352 crores, which is capital in nature. Further, your company has claimed a deduction under section 80B out of the expenditure made under CSR amounting to rupees 618 lakh, which is not admissible as per the Act. This suggests that income targeted to that for the assessment year 1920 has expressed assessment totaling 354.18 crores within the meaning of section 147 of the Act. As per the information, the income escaping assessment is as under. So inadmissible claim of loss of 353 crores and 2 crore 1883 lakhs. Now I file my reply to this. If my lord will find that page 24, which is at page 496. Yes. And if you see para A, name of expenses of Indian rupees 356 crores, which is capital letter. Idea to entail notice of business has stated that in the audit of financials of the company for the year ending 31st March 2020, the associate company has credited a statement of profit and loss account as Indian rupees 75 exceptional items, which constitutes the capital loss but not with treated as a revenue loss. In this regard, the associate only submits that the figures presented in the statement of profit and loss account in the audited financial statements for the year ending 31st March 2018 are reported in rupees and millions. Consequently, the associate company had registered the amount of 652 million. That is Indian rupees 35.2 crores and not Indian rupees 352 crores as the word exceptionalized. The relevant extract of the audited financials are enclosed here after the elected for your reference. Further to the above, the SSC simply submits that the SSC of Kuomoto disallowed the correct figure of 35.2 crores pertaining to exceptional items debited to P&L account in computation of income for the capital assessment rate. The copy of the computation of income is enclosed here and marked with the list of 3 for your revision. Hence, in view of the above, the question that income of estate assessment does not arise to the year in the company. In these, by the interim notice, your itself has stated that the associate company has incurred corporate social responsibility expenditure amounting to indemnity funds and has consequently claimed that deduction under section 18 tax amounting to this point under chapter 68, which is not allowable as per the provisions of the Act. The company submits that in the present case, it had duly offered the CSR expense amounting to its provision the total income in terms of section 37 of the Act. Further, it has claimed deduction under section 80B of the Act amounting to 2 crore 18 while computing the total taxable income. Section 80B of the Act provides for deduction, which has to be made in accordance with and subject to the provisions of the said section, and it does not contain any provision, express or otherwise, which prohibits deduction for donations which are incurred on CSR activities, except donations to Swachh Bharat Trade under section 80G3HK and donations to the Clean Ganga Fund under section 80G3HK of the Act. Since the provision intended certain restrictions to only 2 CSR expenditures, that is, the Swachh Bharat Post and the Clean Ganga Fund, and has impliedly not made any prohibition restriction in respect of claim of CSR expense in other cases, which is otherwise eligible for section 83. Accordingly, if the donations in lieu of CSR activity are made to specified notified institutions by the companies, the CSR expenditure can be eligible for deduction in the section 80G of the Act, subject to the conditions stipulated in the section. It may be noted that this deduction shall be allowed while computing the total income, and the quantum of deduction will be 100% or 50% of the sum paid based on the entity to which the donations are made. In this context, your good self may kindly note that the donations made by the company are to specified notified institutions and not on account of Swachh Bharat Trade and Clean Ganga Fund, which are specifically excluded from eligibility of deduction under section 80G of the Act, and hence the donations which are incurred on CSR activities are entitled for deduction under section 80. In this regard, the SSC humbly submits that the Honorable ICAC Calcutta Why do a recent order dated 11th March 2025 in the SSC's own case for assessment for 2021, it is the immediately allowed the contribution made. Why do CSR expenses a deduction in the section 83? The court relied on various judicial precedents and directed their good side to allow the deduction in the section 83 of the Act. Copy of the IPAP order is inside. Wherewith can mark the registered code for the effect. Further to the above, reliance is placed on the judicial precedent of the jurisdictional IPAP in the case of JMSM mining, where it was held that explanation to the section 37(1), which denies deduction for CSR expenses by way of business expenditure, is applicable only to the extent of computing business income under Chapter 4B. The said explanation cannot be extended or incorporated to CSR contribution, which is otherwise eligible for deduction under any other provision or chapter, such as donations made by a charitable trust that's registered under AP3. Accordingly, it was held as under. Therefore, since the SSC satisfies the conditions of the AP3 of the Act of the donation, the SSC claim for deduction of CSR expenses contribution under AP3 was allowed after inquiry by the A. Thus, we are of the opinion that the action of the A in allowing the claim under AP3 is a plausible view and in line with the nature of the decision. Further, the jurisdictional IPAP in the case of LNP Finance held that where the SSC company incurred corporate social expenditure as mandatorily required under 135 of the Act, Companies Act, and out of the total CSR expenditure, certain expenditure was made by way of donations to eligible. The SSC was not barred from claiming deduction under Section 83 in respect of donations made to approved institutions, even though the same similar view was also expressed in the following judicial pronouncements. We refer to several other tribunal decisions also. In view of the above judicial precedents and the decision of the IPAP consequently referring to case for assessment of prosecution, it is humbly submitted that the SSC was not barred from claiming deduction under Section 83 in respect of donations made to approved institutions, even though the same was made in the therefore, the question that informal escape assessment does not arise for the year under consideration. So I find my objections. Then he passes an order under 148A1, which my lord will find sorry, before that, my lord will just see the tribunal's order at page 509. The relevant discussion is at page 523. So that order is a marked order. Can I hand across? Not a problem. 523. 523, para 33, 32 onwards. The issue raised in ground number 10 is against the disallowance of deduction under APC. The facts in brief are that during the year, the SSC claimed the deduction under APC of the so-and-so. Accordingly, the learned AO called upon the SSC to furnish the details thereto, which was supplied by the SSC by a submission dated so-and-so, wherein the SSC furnished all the details in respect of the relation's name. The AO observed that the SSC has incurred expenses amounting to rupees so-and-so on account of corporate social responsibility. In accordance with the Companies Act, out of this amount, the SSC claimed a sum of rupees so-and-so under VP2 of the Act. According to the AO, CSR expenses were not allowable as claimed either directly or indirectly, and therefore the said claim was disallowed, which was affirmed by the learned dispute resolution panel in its direct. After hearing the rival contention and perusing the materials available on record, we find that the issue is clearly covered in favor of the SSC by a decision of the coordinate bench in the case of JMS mining, where it was held that explanation to section 37(1), which denies deduction for CSR expenses by way of business expenditure, is applicable only to the extent of computing business income under Chapter 4D. The said explanation cannot be extended to improper CSR contribution, which is otherwise eligible for deduction, under any other provision of the Act, that is under section 80G. Similarly, the coordinated bench in the case of alleges services held that the benefit of the claim under Chapter 6A, which is considered for computing total taxable income, cannot be denied merely because such payment forms part of CSR, as it would lead to double disallowance, which is not the intention of legislature. Further, the tribunal held that, apart from the two restricted contributions, other contributions made under 135(5) of the Companies Act are eligible for deduction under 80G without examining the intent behind the donation made by the company. The case of the SSC also finds forth from the decision in the case of Britannia Industries. Considering the facts of the case, in light of the above decision, we are inclined to set aside the DRP's directions and direct the AO to allow the deduction under 80G. So clearly, before the written notice was issued, there was a decision of the jurisdictional tribunal in my own case allowing the deduction. Now please see his order on the objections, which my lord will find at page 526. He sets out the background, he sets out my reply. And then if my lord will go, his findings start from para 5.1 at page 531. Yes. So far as the first issue is concerned, he accepts my submission. My lord will just be page 534. On the issue of the alleged capital loss of rupees 352 crores, the information initially suggested. Yes, no income has escaped. No estimation. Then on para B, on the issue of deduction under section 80G, in respect of CSR expenditure, this contention is not acceptable for the following reasons. The objective of CSR is to make corporate India a stakeholder in the development of the country. Accordingly, as per section 135 of the Companies Act, some companies are required to spend at least 3% of the average net profit of the company made during the financial year on CSR activities. Prior to passing of the financial 2014, there were several instances wherein courts were seized with the question of whether CSR expenditure would qualify as business expenditure in 2021. The decision propounded that CSR expenditure qualified as expenditure only and exclusively made out for the purpose of business or profession, and as such would be allowed under a business expenditure. However, the finance bill provided for not allowing CSR expenditure as deduction under section 37. According to the new amendments, under subsection 1 of 37, any expenditure incurred by an SSE on the activities relating to corporate social responsibility referred to in section 135 of the Companies Act shall not be deemed to be an expenditure incurred by the SSE for the purpose of business or profession. This amendment takes effect on 1st April 2016 and accordingly applies in relation to assessment of 15, and subsequent years. Explanation 2 of section 37 reads, for the removal of doubts, it is hereby declared that for the purpose of subsection 1, any expenditure incurred by an SSE on the activities relating to corporate social responsibility referred to in 135 of the Companies Act shall not be deemed to be an expenditure incurred by the SSE for the purpose of the business or profession. The intent of Parliament in bringing the said provisions is given in the explanatory memorandum to the Financial Bill 2014 and is reproduced as under. CSR expenditure being an application of income is not incurred wholly and exclusively for the purpose of carrying on business. As the application of income is not allowed for deduction for the purpose of computing taxable income of a company, amount spent on CSR cannot be allowed as a deduction for computing the taxable income of the company. Moreover, the objective of CSR is to share the burden of the government in providing social services by companies having net worth, turnover, profit above a threshold. If such expenses are allowed as tax deduction, this would result in subsidizing of around 1/3 of such expenses by the government by way of tax expenditure. The existing provisions of 37(1) provides that deduction for any expenditure which is not mentioned specifically in sections 30 to 36 shall be allowed if the same is incurred only and exclusively for the purpose of carrying on business or profession. As the CSR expenditure with an application of income is not incurred for the purpose of carrying on business, Such expenditure cannot be allowed under the existing provisions of section 37 of the Act. Therefore, in order to provide certainty on this issue, explanation 2 has been inserted to section 37. It clarifies that for the purposes of 37(1), any expenditure incurred by an SSE on the activities relating to corporate social responsibility referred to in section 135 of the Companies Act shall not be deemed to have been incurred for the purpose of business and hence shall not be allowed as a deduction under section 37(1). So the next sentence is important. However, the memorandum to the Finance Number 2 Act 2014 provides that CSR expenditure, which is of the nature described in 30 to 36, shall be allowed as a deduction under those sections, subject to fulfillment of conditions if any specified therein. Thus, it is clear that CSR expenditure referred to in 135 cannot be claimed as tax deductible expenditure under 37(1). However, CSR expenditure which is of the nature described in the 30 to 36 was allowable as a deduction. Say CSR expenditure laid out or expended on scientific research related to business is allowed under 35(1)(1), 35(1)(4), etc. The Act has specifically provided that CSR is not a business expenditure. Now, if the SSE's claim of such expenditure is allowed under 80G, it would render the amendment infructuous. If Parliament's intent was to allow such claims, it would have added 80G as well along with the sections 30 to 36 in the memorandum while stating the intent. The purpose of CSR is to ensure that companies share the burden of providing social services. Granting deduction for CSR expenditure would amount to the government effectively bearing 1/3 of the expenditure. Ministry of Corporate Affairs has answered questions relating to the benefit of CSR in the following manner. What tax benefits can be availed under CSR? Ministry of Corporate Affairs answer: no specific tax exemptions have been extended to CSR expenditure. Finance Act 2014 also clarifies that expenditure on CSR does not form part of the business expenditure. A company can run a school on its own as a part of its CSR activity. Expenditure incurred would not be eligible for claim either under 37 or under 80G. Alternatively, as part of the CSR activity, the company can give money to a charitable institution which is in the field of providing education. The institution will provide a certificate under 80G to the company. Now, if the claim of the 80G is allowed to the company, it would practically mean that in the first scenario, it will not get any tax benefit, whereas in the second scenario, it will receive tax benefit. Such differential treatment for the same activity cannot be the intent of Parliament. Why should tax outgo of a company increase when it chooses to do a charitable activity on its own, namely vis-a-vis getting the charitable activity done by a charitable institution? Why would any company prefer doing CSR activities on its own? Section 80G2 reveals that any sum paid by the SSE to the previous year is to be in the nature of donations to various entities. The relevant part is under when they have extracted this amount. Therefore, it is important to note that the sum paid needs to be a donation for the purpose of being eligible for a deduction of the 50. The meaning of the word donation is not included in the Act. The dictionary meaning of the word donation is that it is a gift of charity, humanitarian aid, or to benefit a cause. A donation may take various forms, including money, arms, services, or goods such as clothing, toys, food, and vehicles. A donation may satisfy medical needs such as blood or organ transplant. However, the dictionary meaning of the word donation refers to an amount paid voluntarily by a person, and that too without any consideration. The donation is a gift. The voluntary act on the part of the donor is thus an essential evidence of the amount to be treated as part paid and donated. However, in the instance case, CSR amount is not paid by the SSE voluntarily. CSR contribution is made by the SSE of the government as per section 135 of the Act and not as a voluntary charitable donation. The expression shall ensure in 135 clearly implies that there is a mandate to spend 2% of the asset of profit on CSR activity. The sum paid by the SSE cannot be considered for the purpose of section 80G as the element of charity is miscellaneous. The main characteristics of charity is that it's purely voluntary and there is no legal obligation to make that contribution. The amount spent on CSR activity, even though it's contributed to the areas where 80G deduction is available, but the same lacks voluntary character and partakes the nature of an obligation to be fulfilled. a necessary requirement imposed by law in accordance with 135 of the Companies Act. The legislative intent behind the insertion of CSR provision was to ensure participation of the corporates in the growth and overall well-being of the society by making meaningful monetary contributions. There are many areas where the government is unable to reach due to logistics, resource, or regulatory constraints. Therefore, the concept of CSR spends is introduced to make the corporates, only those which are eligible, not all, to share the burden of the government to provide benefits to the society by and large. However, if the corporate chose to spend only in those areas where equity is available, it will defeat the very intent of the government for opening the corporates to share its burden, and it eventually will result in subsidizing the expensive income of corporates. It will be the government who will eventually end up bearing the burden of the CSR expenses by way of reduced taxes collected. This certainly was not the intent of the legislature. And then, my lord, we see paragraph C. Also pertinent to know that the IPAT has allowed such deduction 2021 in the case of the SSC. The matter has not attained finality, and the revenue is well within its rights to consult contrary in 1920 and to prefer an appeal before the Calcutta High Court. Hence, the claim for deduction that equity amounting to the so and so is prima facie negligible and has resulted in under-assessment of income to that extent. Now, therefore, my lord, he says that you don't get a deduction that equity in respect of expenditure incurred on CSR. So that is contrary to the plain language. Just see the sections, just two sections if I can choose. Please see section 37(1). Yes, sir. Subsection 1. Yes. Any expenditure not being expenditure of the nature described in sections 30 to 36 and not being in the nature of capital expenditure or personal expense of the SSC laid out or expended only and exclusively for the purpose of a business or profession shall be allowed in computing the income chargeable under the Act profits and gains of business or profession. And then explanation 2, for the removal of doubt, it is hereby declared that for the purposes of subsection 1, any expenditure incurred by an SSC on activities relating to corporate social responsibility referred to in 135 of the Companies Act shall not be deemed to be an expenditure incurred by the SSC for the purpose of the business or profession. So the fiction only says this is not expenditure incurred for the purpose of business or profession. That's all. And even the memorandum says if you can claim it under 30, or for example, look at 35. Yes. So section 35 gives a deduction for expenditure for scientific research. In respect of expenditure on scientific research, the following deductions shall be allowed. And then if you see small Roman 2, an amount equal to 1.5 times of the sum paid to a research association, which has its object the undertaking of a scientific research, or to a university, college, or other institution to be used for scientific research. So if you give it to a university for college for scientific research, you get a deduction. That the board also says. So the argument that it is an application of income and therefore you can't get a deduction is not right. Then please see 80G. What is telling is the language of 80G. APG 1 says yes, in computing the total income of an SSC, there shall be deducted in accordance with and subject to the provisions of this section. In a case where the aggregate of the sum specified in subsection 2 includes any sum or sums of nature specified in so many subclauses, the whole of the sum. In any other case, 50%. So dependent upon which institution you give the donation to, you get a deduction either of 100% or 50% of the amount donated.
And then subsection 2 says, the sums referred to in subsection 1 shall be the following. Now, what is interesting is small Roman 3HK. The Swachh Bharat course set up by the central government, other than the sum spent by the SSC in pursuance of corporate social responsibility under subsection 5 of 135. So if you make a donation to the Swachh Bharat course, which is part of your CSR obligation, you don't get a deduction. And that is specifically provided for. Likewise, my lord will see small Roman 3HK, 3HL. The Clean Ganga Fund set up by the central government where such SSC is a resident and such sum is other than the sum spent by the SSC in pursuance of a CSR under subsection 5. So where the legislature wanted to bar a donation being allowed, or deduction under 80G being allowed to a donation, they specifically provided for. Now, if my lord will just see my return of income. You know that page 90. Page 90. 90. Yes. Schedule 80G, details of donations entitled for deduction under 80G. This is my return of income. Yes. You will see A, donations entitled for 100% deduction. B, donations entitled for 50% deduction. Therefore, my lord will just see the name, charity and foundation, Center for International Development Services, Mamta Health Institution for Mother and Child, Mind Foundation, Oxfam India. So none of them are to the two specified institutions. Now, if it's not there to the, and what does he relies on the explanation, but the explanation only says it is not for the purpose of your business. 80G has got nothing to do with that. My lord, if there is a decision of the High Court of the tribunal in my own case, can you then say that income has escaped assessment? When you issue the notice, that decision was there. So just in that context, let me just refer to two or three things. Firstly, Bombay High Court judgment in the case of Bank of Baroda. It is reported in 256 ITR 385. Mr. Bhattacharya, what has happened to that ITAT order? Have you preferred appeal against that?
No. We are. My instruction is that we are going to prefer appeal, but we are not accepting this tribunal order.
Order of March 25.
Yes, March 25. But we are in a situation to file the appeal. We are not accepting the proposition. And you know, subject to lawsuit correction. And what my learned friend says, this is the court, I believe, with great respect. Now, the court are now making the situation is this court, the constitutional court has been making the deck of the assessing officer. Now, all the submission, with due respect, I say that even if the proposition is correct, the platform is not correct.
No, but Mr. Bhattacharya, if the tribunal has passed an order, which till such time is set aside is binding on the assessing officer in case the point which is involved before the tribunal, point which is involved between the parties in the tribunal is also the point which has fallen for consideration of the assessing officer, merely because it does not get the bar of res judicata does not get attracted. The assessing officer will not be seen to, will not be acting within his jurisdiction by trumping the order of the tribunal and passing certain orders which he in his own wisdom feels is correct and the tribunal is incorrect. That authority he will not have, because then he will have to show that there is a factual difference which allows him to get around the principle of consistency also.
Now that your lordship is subject to lordship correction, your lordship is considering that under 140th stage. Your lordship is
right.
not considering the
serious stage.
not
because you are
considering
reopening something
that
which is closed.
prima facie without finding of the jurisdictional assessing officer that the income has got escaped. It is not that
on
the
what basis?
proposition
On the basis that he has a different opinion to hold on a point on which the tribunal has held an opinion which is binding on him till such time
that
it is
yes,
satisfied.
with the respect to tribunal following the order of the another order and followed the pass the order in case of the assessee. But whether that order also take consideration of the 2014 amendment, whether the the proposition of CSR has been fully taken care of in those orders, that will be established by the assessee in the assessment proceedings.
Assessment proceedings that will be established only if it is a case of fact. If it is on law interpretation, if the tribunal has taken, given an interpretation in law, then in that case, how can the assessing officer give a different interpretation of the same?
Because
that is not permissible.
But the department
actually, if it is different, I can understand. Yes, you can say that.
But
factually, the interpretation of law given by a higher authority will be binding on him.
But very
simple legal interpretation that will be done.
factual is different, also not different. That will also decide with in the assessment proceedings.
In the SSC zone case on the same point, if you have allowed
But same point, whether the earlier CSR contribution to the effect to which institution to
that he does not have. You can prove me wrong, but a lower authority will not have.
I
the authority
will
to say.
show you one judgment of short judgment of Honorable Supreme Court. It also says when the assessment thereafter assessment culminated to the order tribunal and thereafter the High Court passes the order and the Supreme Court also taken care of that fact also. It says there is no bar to for reopening proceedings. Even
if it is a question of interpretation, can the High Court say that the Supreme Court has gone wrong?
No, interpretation has not come finality.
Finality is something which is still, at least in this case, we have not even challenged it.
We will.
Not only in my case, the first order of the Calcutta Tribunal in JMS was of 2021.
But 2000.
Then there are at least 4 other orders. None of them have been challenged in this court.
Now, there may be another situation. Now, in this case also, your lordship is CSR contribution. It is true for and something. And if we want to file the appeal, our the tax effect should be more than 2 crores. And in this situation, it is not that we are accepting the proposition, that we are not in a maybe we are not in a proposition to file appeal because it is barred by the taxable limit.
Very well, show me that.
That is a small judgment. But small fact, case of the revenue was that the SSC company was charging the profit and loss account fiscal during the duties paid during the year as well as labor charges, power wages. However, while value producers, the elements of fiscal duty and the other direct manufacturing costs were not included. This resulted in the undervaluation of the inventories under statement of profit. The revenue therefore reopened the assessment which was upheld by the tribunal as well as High Court on reference. The information was obtained by the revenue in a subsequent year assessment proceeding. But here also,
These are the facts of the case, Mr.
But
Bhattacharya.
all matter is the fact of the case.
No. It's written there. We are of the view that the court cannot strike down the reopening of the case in the facts of this case.
Yes.
Then, yes.
Yes, well,
Yes. Thereafter, the SSC may also prove that no new facts came to the knowledge of the income tax officer after completion of the assessment proceedings. So, if after completion of the assessment proceedings, something new has come, definitely he has option to reopen. But what is new here?
Here,
the 2014 amendment was there before the tribunal also.
Yes, not tribunal also there. Now the 2014 amendment has been properly dealt with or not dealt with.
Then he should have said that it is not. He does not say so in the order also. Does he say in the order that the tribunal has not taken note of the 2014 amendment?
Not said.
Once
He
he
is saying he only then there is no occasion to go into the assessment proceedings.
The order was cited before him.
Yes,
if he disagrees with the order, he will definitely say that why this order is not binding on him.
Then
it is not barred by res judicata, whatever.
Submission will be the assessment proceedings will be stopped with the 148 proceedings. There is no occasion.
If it has to be stopped, it has to be stopped, Mr. Bhattacharya. Merely because you have issued a notice under 148 doesn't mean that it has to be concluded with an assessment order.
Submission, then the concession of the registration will be frustrated.
No, not at all. It is not the intention of the legislature that every time the assessment is opened, reassessment proceedings are initiated, they have to culminate into an order of assessment. If that had been the intention of the legislature, that even time-barred proceedings would have culminated in an order of assessment and then being set aside upon being time-barred. That cannot be the intention of the legislature. Then you cannot just simply say that merely because the assessing officer has framed up a mind, issued a notice under 148, therefore that must culminate in an order of assessment. That can never be the intention.
No. My submission is that there is a mechanism in the statute.
Correct. The mechanism in the statute has to be rightly resorted to. Once he has activated it, definitely he has right to activate. He has activated it, but then he has to reach a conclusion which is legal. He cannot reach a conclusion which, according to his own wisdom, is correct. He may be correct, but he should be ready to face counters.
But my respectful submission of the assessing officer given the plausible view for reopening. It is not that he will pass a judicial order.
Very good. Yes, Mr. Padiwala, your judgment of HON'BLE.
Yes, sir. So just see this Bank of Baroda.
What is the tribunal's decision? Tribunal has dealt with that 2014 amendment.
Yes.
Dealt with.
Yes.
Can you show me that paragraph?
So just go to para 33 first.
Para 33 of?
Para 34 of that tribunal order.
Page?
No, that was at page 423. Sorry, page 520.
Yes.
After hearing the evidence, the reason of material available on Japan, we find that the issue is fairly common in provincial. While the question of the coordinate identification of payment money, when it was held by the explanation through to section 27(1), which is the amendment, which denies deduction for QSR expenses by your business expenditure is applicable only to the extent of business income under chapter 4C. The said expenses cannot be extended or imported to QSR contribution, which is otherwise eligible for deduction under any other provision of chapter that is under section 150. Similarly, the coordinate date in the case of anything, service to India held that the provision of claim under such chapter is saying, which is considered for subsequent social taxes income, cannot be denied merely because of payment forms part of CSR, as that it leads to double disallowance. It would not be intention of the legislature. Whether the tribunal held that, apart from the two restricted contributions, that is the cross Bharat course and the series and other contributions made under 135 of the Companies Act are eligible for deduction by ECG without examining system to have a relation with the customer. The case of the SSC also finds fault for the discipline in the family industry, including the activities.
And if my lord will just see my application,
The JMS mining decision of 2021, has this been challenged before the High Court?
I have not found anything on the map. When you see page 499, there is also a reference to another Calcutta tribunal decision in the case of LMT Finance.
Yes.
But frankly, the tribunal across the country is taking a uniform view on this matter.
Any matter has walked up to the High Court from the tribunal? No.
There are cases of reopening on this issue where the matter has reached the High Court and the High Court have struck it down. But that is under the old provision on reason to believe, failure to disclose, etc. But they struck it down, saying that no, there can be no question of difference. I'll show those to my lord. So just see this. Please see para 16 of Bank of Baroda. Para 16. At this juncture, we cannot resist from observing that the judgment delivered by the tribunal was very much binding on the assessing officer. The assessing officer was bound to follow the judgment in its true letter and spirit. It was necessary for judicial unity and discipline that all authorities below the tribunal must accept as binding the judgment of the tribunal. The officer, being an inferior officer vis-a-vis the tribunal, was bound by the judgment of the tribunal, and the officer could not have tried to distinguish the same on untenable grounds. In this bias, it will not be out of place to mention that in the hierarchical system of court which exists in our country, it is necessary for each lower tier, including the High Court, to accept loyally the decision of the higher tier. It is inevitable in the hierarchical system of courts that there are decisions of the Supreme Appellate Tribunals which do not attract the unanimous approval of all members of the judiciary. That the judicial system only works if someone is allowed to have the last word, and the last word once spoken is loyally accepted. The better wisdom of the court below must yield to the higher wisdom of the court above, as held by the Supreme Court in the case of CC versus Dunlop India Limited. In the aforesaid background, for the reasons stated there above, the impugned officer is quashed and set aside. Great petition is allowed. And to the there are other judgments to the similar effect. But I may just show my lords a judgment in the case of Karanja Terminal. So just see para 2 of the judgment on the second page. The principle of judicial discipline requires that the orders of the higher appellate authorities should be followed unreservedly by the subordinate authorities. The mere fact that the order of the appellate authority is not acceptable to the department and is the subject matter of an appeal cannot be ground for not following it unless its operation has been suspended by a competent court. Paragraph 6 of the judgment of the apex court in the case of Samlakshmi Finance Corporation reads as under. Sri Reddy is perhaps right in saying that officers are not actuated by any malafide in passing the impugned order. They perhaps genuinely felt that the claim of the assessee was not tenable, and that if it was accepted, the revenue would suffer. But what Sri Reddy overlooks is that we are not concerned here with the correctness or otherwise of their conclusion or of any factual malafide, but with the fact that the officers in reaching that conclusion bypassed two appellate orders in regard to the same issue which were placed before them, one of the collector appeals and the other of the tribunal. The High Court has, in our view, rightly criticized this conduct of the assistant collector and the harassment of the assessee caused by the failure of these officers to give effect to the orders of the authorities higher to them in the appellate hierarchy. It cannot be too vehemently emphasized that it is of utmost importance that in disposing of quasi-judicial issues before them, revenue officers are bound by the decision of the appellate authorities The order of the appellate collector is binding on the assistant collectors working within its jurisdiction, and the order of the tribunal is binding upon the assistant collectors and appellate collectors who function under the jurisdiction of the tribunal. The principles of judicial discipline require that the orders of the higher appellate authorities should be followed unreservedly by the subordinate authorities. The mere fact that the order of the appellate authority is not acceptable to the department in itself an objection to be raised and is the subject matter of appeal can furnish no ground for not following it unless its operation has been suspended by a competent court. If this healthy rule is not followed, the result will be only undue harassment to assessees and chaos in the administration of tax laws.
Well, all these proceedings will not, after Millard under section, you should kindly note that after Millard under section 264. Millard assessment order passed, thereafter revision petition before the Millard CIT, thereafter Millard read petitions.
These orders, Mr. Bhattacharya, these orders are not in the facts of the case. They are laying down a principle.
Well, yes,
that will apply across.
Millard principle.
The ratios are of two kinds. One, which you call out from the facts, that will apply if only similar facts are there. There are certain ratios which are in the nature of principles. They will apply across, whatever may be the fact. These are principles. They are well settled.
I am Millard, with deep respect, I am asking this question to Millard myself, in which platform? Under Article 223 of Constitution of India. But I am Millard.
There are 4 or 5 exceptions. For this case, at least 148 AD order or 148 A3 as it is now termed, there is no appellate remedy.
No,
there is no appellate remedy. Reopening is a matter which visits the SSC with civil consequences because it's adverse in nature. So therefore, it is definitely assailable in writ proceedings. Number one. Number two, if it is in violation of fundamental rights like natural justice and all, if it is absolutely egregiously against law, provisions of law, the manner in which the assisting officer acts, suppose trumping all orders which are passed by superior authority. Definitely,
now that my alternative submission will affect that, but I will show your lordship judgment from that your lordship knows Taylor and Taylor, and thereafter the Imperial. It says the act should be done which has been laid down in the statute. But in the, what is the case? The case of the assessee, it is not tribunal will not given the benefit to the assessee. Now the tribunal will not extended the provision giving the benefit to the assessee under section 80G, whereas the act itself says the benefit cannot be given.
No. Tribunal has read section 80G in a manner in which SSC can be benefited. It can be read both ways. Tribunal has accepted one of the manners. You say that it has been misread by the tribunal. He will say that it has been correctly read by the tribunal. It will be ultimately for the higher court to decide whether it has been correctly read or incorrectly read. Till such time that the tribunal's decision holds field and the department has not proceeded in appeal against the order, the lower authority should follow the order.
Now, the position is that in all the matters,
it is not for the lower authority to say that the appellate authority has misinterpreted the provision.
No,
the correct option would have been to prefer an appeal, obtain stay.
No,
we cannot have both. Best look at the situation the SSC is facing. Look at the situation the SSC is facing. Rightly or wrongly, there is an order passed in favor of the SSC. The SSC is entitled to the benefit and advantage of the order. That order is cited before the lower authority. The lower authority blissfully refuses to obey the order of the. That is what is being done.
It says we are going to prefer the appeal. It not says we are not.
It's as good as saying no. Going to prefer appeal means what? After 1 year,
because the position because the position has not been settled down. Because the tribunal order.
You file your opposition. I am staying it.
Okay, before that, for my satisfaction, your lordship kindly allow me to place only 10 minutes to my case.
Very well. Because it will unnecessary wastage of time. You come up in because why do you oppose stay also? Is it not a case where stay also should be granted? In any case, Jiao issue is there.
Not taken.
Yes. Supplementary affidavit. Leave was granted on the first day when it was moved before the coordinate bench. I have seen it.
I have also preserved my right to take the point by your supplementary affidavit amending the petition.
Ground, even if it is not taken in the writ petition, if it is a ground which is available, that can always be urged before the court because it's not a factual ground, it's a legal ground. Whether the jurisdictional assessing officer has jurisdiction to pass or not. No other document is required to be brought on record. What is there in the writ petition, on the basis of that, it can take that ground.
But if your lordship will not close the lordship mind, then it is difficult. But I must say, this is not.
No, the difficulty is if we can continue with one matter for the entire day, despite knowing that this is the situation.
This is the situation, then the assessing will not get 1 hour chance that we are not getting 10 minutes.
So you come up with something substantial because whatever you have thus far submitted has not cut ice.
But my respectful submission is before your lordship that the provision of amendment came in the year of 2014. If the tribunal does not take proper care of it. If say, may I place the this is the group of 2014. This is very much clear. No uncertain term it says that.
Yes.
Page 2 I have only giving certain relevant portion because it deals volume. The first page has given and the page number 13, which says about corporate social responsibility. Below portion, below portion. But under Companies Act 2013, certain companies which have net worth of 50 crore certain such, net profit of certain such, that I am hurriedly going through and are required to spend certain percentage certain such under the executive provision of the Act. Expenditure incurred only or exclusively for the purpose of business is only allowed as a deduction computing taxable business income. CSR expenditure being an application of the income, it is not incurred wholly or exclusively for the purpose of the carrying of the business, as the application of income is not allowed as deduction for the purpose of computing taxable income for a company. Amount spent CSR cannot be allowed as a deduction for the computing the taxable income of the company. Moreover, the objective of CSR is to share the burden of the government in providing social services.
This was copied in the assisting officer's order. I have read it.
What will be the situation? Situation will be that the companies who are spending the CSR responsibility, if all the expenditure going, they are claiming under section 18, then the what responsibility they are performing? It is the case of the HSC out of 4 courts and not 2 courts. They are claiming the deduction. Now, if the 4 courts they can claim 4 crores deduction. Then what is the purpose of the CSR responsibility? That is never the contention of the legislation. And for that reason, you have to kindly see Nazir Ahmed versus Union Period. All the problem is that all the amount which are 2 crores, below 2 crores, and not in a position to file the appeal because it's not the taxable limit is 2 crores, so filing the appeal before the High Court under section 268. But in this, Your Lordship, kindly come to page 381.
Does the CBDT circular not prescribe anything that if there is an important question of law of public interest or something which is involved, then appeals can
Yes,
be preferred.
it
Then
says, but it,
this limit argument is not very pleasing.
but it says, but
If you
now
have to prefer appeal, you can prefer appeal. If you don't want to prefer appeal, then
no, your lordship knows that we are always looking into the tax effect, not more than that. The page 381. The last line, last 3 lines, 381 page. Let me read out. The rule which applies is a different and not less well recognized rule, namely that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all.
yes.
Now, these judgment will not relied upon by the Honorable Supreme Court in different judgment also. I have the judgment. But here what is the situation? Well, only the defense of the assessee is that the tribunal is the subsequent year taking a view that he is eligible. Now that is not the contention of the legislature. It is apparent from the bill and also in the section also. The tribunal expanded the provision for giving the benefits. And the Supreme Court says, relying this judgment, that the act should be done in a manner which that should be done not what I say, no bifurcation is permitted. May I give those judgments? Paragraph 43. Before that, paragraph 41. May I read out? In the aid of this submission, reliance is placed on the observation made by this court in such and such, which is noted and explained in the current decision of this honorable court in such and such, wherein stated, it is the basic principle of law, long settled, that if the manner of doing a particular act is prescribed under any statute, the act must be done in the manner not at all. The origin of this rule is traceable to the decision of Taylor versus Taylor, which was followed by the Lord Rochi in the Nazir Ahmed versus King Emperor, who has stated thereof, and in same principle, and my alternative, another submission is that the Honorable Supreme Court, in a judgment of Commissioner of Income Tax, Andhra Pradesh versus PPG, Raju and Raghunath, it says what is donation? If donation is something voluntary has to be given, it is to be such that nobody can claim any benefit from the donation. Now, in this way, the assessee performing my lord the duties of CSR. This is their obligation. And my lord claiming benefit under section 80G saying donation. And my lord the donation my lord never been my lord I do not find also this donation has been my lord enacted in the my lord act. There is no definition as the donation. Now let you also kindly see what Supreme Court says about the donation. But it is only thing that voluntary something given. Let it is my lord paragraph number 8. Paragraph number 8, middle portion. When Miller, you have to find out when a person gives. When a person gives money to another without any material return, he donates the sum. An act by which the owner of a thing voluntarily transfers the title and possession of the same from himself to another without any consideration, it is the donation. A gift or gratuitous payment in simple English, a donation but donation is something without nobody expecting in return anything. Now that it is a situation without the assessee performing one duty, claiming thereafter claiming the benefit from the duty, expending the situation says under section 37 explanation 2.
But here he is not expecting something in return. He is expecting exemption in payment of tax.
Yes, that is the return. That is the benefit he is taking.
So that
is the benefit he is taking.
He's saying it is not taxable. It is not his own. What will be taxable? Taxable will be something which is his own. This judgment supports him in the sense that since he has given him, he has washed his hands with it. It is not his own. It shouldn't be taxed. That's how he will do.
When the benefit under section 80G is claiming the 50% or 100%, whichever will not the institution, the will not assessee will not reduce its will not profit. In one sense, will not he is getting the benefit.
Very good.
Or I'm only placing not placing judgment because it will take time.
No, you have already taken time. Please take your time now. After accusing me, you please take it. I will put it tomorrow also, so that you conclude. I wanted to cut it short now. Please continue.
Tell them we are getting chance to make argument against.
Not in this court. I don't cut short anybody.
Yes.
That's why I'm taking. I find it reasonable. I found it reasonable today. You did not agree. You please continue. You continue till you exhaust. I will not stop. I thought it can be cut short because issue was short. Now you want me to decide the issue. The problem will be if I decide, you will not be able to prefer appeal now. You will have to prefer before the debate because I'll be deciding this issue now. That is the problem.
Well, I'm making submission for the interim order. He also now.
This is on merit, sir.
Well,
The
he
issue
also,
itself
well,
is on.
my learned friend also makes submission on
Yeah,
merits.
because he will make submissions on merit so that he can make out a prima facie case.
Well,
If
for,
prima
for,
facie-
for not giving me the, well, the interim or I also place my case.
Then this is decision on merit. Law point.
Now that I am relying on judgment of this honorable court where your lordship appeared in a single bench. Page 2, my lord. Paragraph number 2.
Paragraph
number 2. Whole case of the petitioner with the restriction.
Yes.
Is that objection of the response to the notice under section 148 if has not been properly dealt with and discussed, and the improved order is not seeking one, and accordingly petitioner reason giving petitioner the reason giving applicable is not accepting the explanation of the petitioner is not sufficient as satisfactory, in which in my considered opinion cannot be ground for invoking constitutional jurisdiction under article 2. It is the same proposition, same case. This is also a single bench judgment. But only Miller not relying the Miller judgment of Miller Whirlpool Corporation Lordship knows that Miller and Register of Trademarks Mumbai. The Miller principle when the Miller read court can be not approached. Here Miller took if from paragraph 26. The Honorable Supreme Court explained that writ petition may be entertained against the show cause notices where the petitioner seeks enforcement of any fundamental rights, where there is a violation of principle natural justice, or where the order or the proceedings are wholly without jurisdiction, or where the virus of the act is self-challenged. Now the circumstances are made out in the present petition. Simply alleging the foreclosures are without jurisdiction because according to the petitioner perception, the exemptions cover them, or the nil tax rate notification is sufficient. The usual adjudicatory process where such a matter can be effectively adjudicated upon cannot be settled by rushing the writ court and securing staying the adjudicatory proceedings. It is thereafter paragraph number 127. It is well settled that the writ court do not interfere with cases where the statutory remedies are available unless there is clear violation of fundamental rights lacking the procedural perversity. The petitioner has not demonstrated exceptional circumstances what is the intervention. Instead, statutory framework under CGST Act provides the adequate mechanism for addressing the petitioner's concern, including the responding to the show cause notice, participating in adjudication procedure, and availing appellate remedies if satisfied with the outcome.
But in the recent judgment of the Honorable Supreme Court, Supreme Court what dismissed the utility of the apathy. It is going against the judgment of Ilawa High Court. No, paragraph number 7 and 8. Okay. This is reported in 2023 156 statement from 188 LR. The Income Tax Act, may I read out? Income Tax and does not complete equal adjudication on merit of information available or under in our considered view. There is a purpose for not including any further inquiry and adjudication that is on the surface of the or otherwise for the information on the correctness or the information adjudication. The reason for it is obvious under the Act. A detailed procedure has been provided under section 148 of the issuance of the notice, where after the applicable authority has to determine in a manner specified whether income escape assessment and defense of the all the permissible ground remain open to be passed at such stage. The ultimate determination made by the applicant officer under 147 of the assessment is otherwise subject to appeal under section 246A of the Act. Release of the information referable under section 148 thus remains subject to the assessment proceeding initiated by under section 140 of the Act. It is for the reason that issues which require determination at this stage of the proceeding and in respect of which departmental remedies otherwise available is not required to be determined at this stage of the division by the appealing authority under section 148, that is 148A. The scope of division under section 148A is limited to the existence or otherwise of information which suggests the income chargeable to tax has escaped. Thus, in our opinion, issuing order under section 148 of the Act, notice under section 148, instead of warrant any interpretations under article 2 of the Constitution that Act challenge for such order to be available, the assessee while challenging the order passed in the assessment proceeding, consequently notice issued under section 148 of the Act, the rewriting of the anti joint check to the location because the lawsuit is not only. Thereafter, we have the adjective preferred appeal before the Honorable Supreme Court, and we have the Honorable Supreme Court also will have. But not will dismiss will not assess will not withdraw the will essence with the observation of the Honorable Supreme. Yes.
How long will you take, Mr. Bhattacharya?
But I will not only place below the company's corporate social responsibility rule 2000.
Mr. Padiwala, when can you come next?
But would my lord take it up on a Friday?
Fridays, I take up different matters. There is there are assigned matters which I take up on Fridays. So those will gain precedence, so your matter might not be called.
Very well. But can I do it virtually tomorrow as well? Because it needs to have continued.
Tomorrow is a Friday.
Oh, no, that's fine. So can we do it next Wednesday? If I can't come, can we do it virtually? Is all right?
I don't have a problem virtually. Only problem is net because
no, I'll try and come. The only thing is there's something in the Supreme Court. I don't know what it was there this week. It's not reached. I don't know what position it will come up.
We'll give a next date if you are not available.
I'm not.
Likheni. Heard Mr. Padiwala.
Thank you, sir. Thank you, sir.